Good afternoon. I'm Laura Barczewski. In just a few minutes, Missouri Attorney General Andrew Bailey and St. Louis Circuit Attorney Kim Gardner will meet in front of a judge to discuss the so-called quo warranto lawsuit Bailey filed in February seeking to remove Gardner from office. Bailey filed the suit days after a 17-year-old Tennessee girl was severely injured in a downtown crash involving Daniel Riley. Riley violated his GPS monitoring conditions dozens of times since he was charged in September of 2020 with armed criminal action and robbery. Gardner said a judge denied her office's request to keep Riley in jail. That's in contrast to a circuit court spokesman who said Gardner's office didn't file motions to revoke Riley's bond. In Bailey's lawsuit against Gardner, he makes 3 claims. He says she has failed to prosecute cases that are pending in her jurisdiction, failed to confer and inform victims of the procedural posture and ultimate disposition in criminal cases, and neglected her duties by failing to charge new cases referred to her by the St. Louis Metropolitan Police Department. Right now, the Circuit Attorney's Office, 3 prosecutors are responsible for nearly 500 felony cases. On Monday, 5 on Your Side's Christine Byers sat in 3 murder trials that were scheduled to begin this week. The prosecutors who were assigned to them either resigned or have taken a leave of absence.
Stanley Barge is accused of shooting a man before barricading himself inside a home. Prosecutors showed up for this one, but they just got the case on Friday. Jonathan Jones is accused of killing a man on the Arch grounds in September of 2021. No one from the Circuit Attorney's Office showed up for his trial today. The judge gave Gardner 1 week to explain why she shouldn't be imprisoned or pay a fine for being in contempt of court. Deontez Huntley is accused of killing a woman who was taking her 4-day-old son to the doctor in 2020. The judge called Gardner's office Monday to find out if a prosecutor would be coming after about a 30-minute delay and, quote, reluctantly granted a continuance. His attorney, Raphael Morris, is now asking the judge to release his client on bond.
This is very unfortunate, first and foremost for Deontez, who is presumed to be innocent. It's unfortunate for the victims of this crime, who are entitled to be present, to be kept informed. It's an unfortunate situation for the citizens of St. Louis who expect for this system to work, and it's failing everyone, and something needs to be done.
Christine Byers, 5 on Your Side.
Several judges told 5 on Your Side that they've learned 2 more prosecutors have turned in their resignations. Gardner's office did not respond to requests for comment. So she apparently just walked into the courtroom. We can see it's starting to get packed there. This is a live look inside the court proceedings that are scheduled to begin shortly. Those resignations followed the resignation of another prosecutor last Friday. Natalia Ogurkowicz said she did not plan to walk off the job, though her concerns were growing for a while. Here's 5 on Your Side's Brent Solomon with more.
5 on Your Side, the first to get hands on this resignation letter and the first to speak with Natalia Ogurkowicz.
My title was Assistant Circuit Attorney in the Homicide and Violent Crimes Unit.
The now former St. Louis prosecutor speaking with us on the very day she told her boss, Kim Gardner, she's had enough.
I felt that I needed to leave the Circuit Attorney's office at this time due to the position that our attorneys have been placed in. Due to the impossible circumstances and the fact that we are expected to do far more than one attorney's job. Right now, what we're expected to do is to be an attorney, to be an investigator, to be a paralegal, and to be a victim services advocate due to the lack of support and lack of structure in the Circuit Attorney's office at this time.
Ogurkowicz was the prosecutor in the Daniel Riley case. That's the man accused of hitting 17-year-old Janae Edmondson with his car, causing her to lose both her legs. The armed robbery suspect was out of jail on bond, but violated his GPS monitoring terms nearly 100 times. That launched Attorney General Andrew Bailey's quest to get Gardner out of office, claiming she's not doing her job.
I can't speak on that given the ethical parameters of an individual who's involved in litigation. but I'm sure that my thoughts, as well as the thoughts of others, are going to become clear because I am fully cooperative with the Attorney General's efforts.
At a crime solutions meeting Thursday, a representative from Gardner's office addressing the community.
The appointed, Attorney General is trying to take away your right to determine who your elected officials are. Your presence, voters, is extremely important to make sure that we keep our city safe. And he wants to say he's the best knower of what the interests are in the city of St. Louis.
The safety of the community requires that this circuit and this office be led with integrity and that the attorneys can be effective in their environment.
Brent Solomon, 5 on your side.
For her part, Kim Gardner last week asked Circuit Judge John Torbitzky to throw out the case against her. Here's a closer look at her 93-page response to the Attorney General's lawsuit.
Attorney General Andrew Bailey not backing down in his fight to oust St. Louis Circuit Attorney Kim Gardner, claiming she's not doing her job. Bailey says nearly 12,000 criminal cases have been dismissed to what he calls Gardner's failures. More than 9,000 cases, he says, were thrown out as they were about to go to trial, forcing judges to dismiss more than 2,000 cases due to what Bailey cites as Gardner's failure to provide defendants with evidence and speedy trials. He claims a toxic environment is running attorneys away from her office. His amended petition is a gross power grab, Gardner responded Tuesday, quote, an affront to the liberties of all Missourians and the democratic process. The circuit attorney says the law allows for removal of an elected official for willful neglect, failure, or refusal to perform duties. Gardner says there is no corrupt intentional acts of misconduct or failure to perform her official duties. She goes on to say, quote, if the AG or the political interests behind his petition were truly concerned about crime in St. Louis, they would seek to assist with resources. While covering this ongoing battle, we've heard from both Bailey and Gardner.
It has rarely occurred in the history of the state of Missouri, but that speaks to what a bad situation we have here in the city of St. Louis and the necessity for immediate action to restore law and order and to find justice for victims. And that's what motivates me.
Because this is voter suppression from the 1960s. I read about this in school, and I'm like, this is, they taking it back. It's tough sometimes, but in the end of the day, I fight so hard because you guys told me you don't want the same old.
Brent Solomon, 5 on your side.
People gathered to support Kim Gardner several times over the last few weeks, including this rally just after the lawsuit was filed. Mercedes McKay takes us to the supporters who say she did nothing wrong.
Circuit Attorney Kim Gardner has not, that's what I emphasize, has not lost the trust of the community.
On the steps of Carnahan Courthouse Tuesday morning, supporters of St. Louis Circuit Attorney Kim Gardner gathered to share one main message.
Kim Gardner is innocent. Yes, she is. She does not have the power or the authority to revoke or change anybody's bond.
The group, made up of members of the Community Justice Coalition, are calling on Judge Brian Hettenbach to step down. They say he's the one responsible for 17-year-old Janae Edmondson losing her legs. The group claimed the judge refused multiple times to revoke bond for the suspect in this case, Daniel Riley, despite dozens of violations.
He is a danger to the residents of the city of St. Louis.
Critics of Gardner say the prosecutor's office is responsible, not the judge, and they are pushing forward to remove her. Representative Justin Sparks is a co-sponsor of House Bill 301. Part of this bill includes giving the governor power to appoint a special prosecutor for the city of St. Louis.
We as a legislature agreed that what was going on in terms of violent crime in the city of St. Louis had become an issue that now was affecting the entire state.
Representative Sparks says through their research, it became apparent that the circuit attorney's office needed help. He says this was one of several different ways of trying to do that.
We want people to be able to come and enjoy our city and interact with our citizens and know what an amazing place St. Louis really is. And that never gets talked about anymore. Frankly, it's high time we do something about it.
Mercedes McKay, 5 on your side.
House Bill 301 is still making its way through the legislature. It has several steps left before it could end up on Missouri Governor Parson's desk. Let's take a look at the major players in this lawsuit. First, 5 on your side's Christine Byers profiles Judge John Torbitzky.
A special judge had to be appointed to oversee this case because all of the judges in St. Louis asked to be recused. That's because all 31 of them agreed that they could be called as witnesses to some of the allegations against Gardner. So here's what we know about the man who just got the job. Torbitzky graduated from St. Louis University Law School 10 years ago. He clerked for a Missouri Supreme Court judge before going into private practice, and Governor Mike Parson appointed him to the Missouri Court of Appeals in 2021. He's also a St. Louis native. In 2018, Missouri Lawyers Weekly named him an up-and-coming honoree. He told the publication he would likely have become a teacher or a journalist had he not become a lawyer.
Here's another live look at the courtroom where proceedings are scheduled to begin shortly. That is Circuit Attorney Gardner, who has made her way into the courtroom. We have several people packing the room, as well as journalists, ahead of these proceedings, which are scheduled to begin in just a few minutes at 1:30. People are still preparing, making their way into this hearing, and we'll see what else comes of this hearing today.
Ladies and gentlemen, I was just reminded of one more thing. If you go out to use the bathroom before we take a break, you would not be able to get back in. If you go take, if you answer the cell phone when you go out, you would not be able to get back in. So keep that in mind. Ceremonial courtroom is now in session pursuant to adjournment. The Honorable John Torbitzky presiding. Ladies and gentlemen, please be seated, and thank you.
Good afternoon. Before we get started today, I'm just going to give a couple of reminders to everybody in the courtroom. First of all, there are no cell phones to be used today here, no laptops. You like to keep all your electronic devices put away. Next, we need to keep it quiet in here. We need no talking, no disruptions, no outbursts. This is the opportunity for the parties to be able to be heard here, and so we really need to have order. Next, we'd just like for everybody to remain seated, not be up and down. If you need to leave, you leave only in an emergency, please. If once you've left, we're not going to allow you to come back into the courtroom. If there are any questions about anything, please feel free to direct them to our security personnel during the break. But otherwise, don't approach the bench or the witnesses, or there aren't any witnesses today, or the attorneys or the bar. With that, so we are here today, as we all know, in the matter of Missouri Attorney General versus Kimberly Gardner. It's case number 2322CC00383. We got a number of motions to take up. Before we do so, I'll have the parties just announce themselves and the people that they represent. And we'll just, if we want to start over here on my left. For the attorneys, we are, this is being streamed live and recorded otherwise. And so if you could use this microphone here during your presentations, that would be great. For announcements, you can just go ahead and stand.
John Jeffers from the law firm of Kaiser Dillon, here on behalf of the Circuit Attorney's Office.
Thank you, Mr. Jeffers. Thank you.
Mike from County Law Group on behalf of Ms. Gardner. Please the court, Jonathan Sternberg, also on behalf of Ms. Gardner.
Your Honor, Paige Slinsky on behalf of non-party subpoena recipient Serena Wilson.
Thank you.
Your Honor, Bill Corrigan from the state of Missouri.
Greg Goodwin from the state of Missouri.
Natalie Warner from the state of Missouri.
Andrew Crane from the state of Missouri.
Thank you. All right, so I think, yes.
We also have other counsel.
Okay, I'm sorry.
Judge Booker Shaw here on behalf of the judges of the 22nd Circuit.
Wonderful, thank you.
Your Honor, Bob Plunkett on behalf of Tayo Berkowitz.
Thank you, Mr. Plunkett. All right, we got everybody in? Wonderful. So I'm going to go through kind of the list of motions that I have to take up, and let me know if there's anything I'm missing. First of all, we have the motion to dismiss the original petition that's still technically pending. I assume that everybody would agree that that should be denied as moot at this point?
Yes, Your Honor. Yes, Your Honor.
Okay. Next, we have the motion to dismiss the amended petition, the motion to stay discovery. We have a motion to quash filed by the Circuit Attorney's Office, a motion to quash on behalf of Ms. Wilson Griffin, a motion to expedite discovery, a motion to expedite trial setting, a motion for leave, and then we have kind of the remaining requests from the motion for leave to amend and set a trial and schedule it for hearing, which I think mostly has been addressed. But is there anything else that anybody had a motion that they wanted to argue that we haven't taken up or haven't mentioned already? No? Wonderful. Well, unless you all think we should do it differently, I think that we should start with the motion to dismiss. Okay? Counsel?
May it please the court. Again, I'm Jonathan Sternberg, and I represent Circuit Attorney Kim Gardner. Your Honor should dismiss the amended petition in quo warranto that the Attorney General filed in its entirety. It's a poorly considered political move that doesn't remotely state a lawful claim for Ms. Gardner's ouster under the well-established law of Missouri. Under the only authority that the Attorney General has invoked, which is Section 106.220 of the revised statutes, specifically its subsections or subparts allowing for removal of a public officer for a, quote, willful or fraudulent violation of a public duty or willful neglect of a public duty, he has to show that Ms. Gardner intentionally failed or refused a duty. He omits that from both his petition and from his response to our motion to dismiss, which was filed yesterday afternoon. And Your Honor, that's a fairly detailed motion or opposition, 37 pages long. I did not have time to file a reply in the last 12 hours to that. We'd asked for a week to file a reply. I'm an appellate guy, and as are you, and we're used to filing reply briefs, so I would ask for a week to do that.
Do you have any objection to the request for time to file a reply? You don't have to answer right now either, if you don't want.
It's just another delay, Your Honor. They got 3 weeks to do their response to our lawsuit. We had a week to respond. We responded last night at 4 o'clock in the afternoon. I would, as we'll take up with our motion for expedited trial, we're asking for an expedited trial, so I would object to another week.
Okay, thank you.
I'll address it as best I can. Perhaps we can take that up again later.
Thanks.
But he omits from both his petition and his opposition to our motion to dismiss that the standard is that he has to show that Ms. Gardner intentionally failed or refused a duty. His allegations, even taken as true, don't remotely come close to meeting that bar, which is why I guess he omitted that standard. You see, in our state, unlike in some other states, neither the governor nor the attorney general controls county prosecutors, or here in St. Louis, the circuit attorney. The governor and the attorney general usually are elected by the people of the state, and county prosecutors, or the circuit attorney here, are separately elected by the people of their communities. And every 4 years, they answer to those people, as Ms. Gardner did in the last election, where she won by 74%. Only a few years ago, in State ex rel Gardner versus Boyer in 2018, the Supreme Court, addressing Ms. Gardner herself, stated that she has been elected to exercise her discretion to the dictates of her own judgment and conscience, uncontrolled by the judgment and conscience of anyone else. Despite this, in this case, our new unelected Attorney General, Mr. Bailey, has decided he doesn't like how Ms. Gardner is doing her job and seeks to unseat the people's choice. But because Mr. Bailey doesn't supervise or control Ms. Gardner, the law gives him very little room to seek that. And what he's chosen to invoke is 106-220. Again, it's standards of willful or fraudulent violation of a public duty or willful neglect of a public duty.
And that has been alleged in the petition.
Certainly. He alleges the words willful neglect. The question then becomes...
He mirrors the language of the statute.
He mirrors the language of the statute. That's correct. The issue in a motion to dismiss, of course, is whether not the conclusions, but the well-pleaded facts, the well-pleaded allegations meet the legal standard under the statute at issue. Here they don't. In our motion to dismiss, we cite what I thought at the time was the only 12 ousters in the history of Missouri under this statute. The statute's about 150 years old. I actually found another one while preparing for this yesterday. It's a case from 1954 where a county assessor solicited bribes, something intentional. Each and every one of those cases, though, were for intentional failures or refusals. A recorder of deeds who intentionally fudges numbers about the amount of money she received. Sheriffs who intentionally detain prisoners unlawfully longer than they know they're allowed to do so. Sheriffs who misrepresent costs and pocket the difference. County judges, what we would call county commissioners today, who direct that bond money go to their friends. And importantly, only 2 prosecutors in the history of Missouri, both in the 1930s, in the Wymore and Graves cases, who intentionally turned a blind eye toward notorious organized crime due to their own involvement in those same offenses. That's what it takes to make for a willful or fraudulent violation or willful neglect. Now, the most recent authority from the Supreme Court about this is the Foote case. They call it Fuchs, we call it Foote, from 1995. They note in Foote that these are 2 standards, right? Willful or fraudulent violation or willful neglect. Willful or fraudulent violation, the Supreme Court says, means malfeasance, that is, misconduct in the performance of official duties. Now, they, in their opposition, argue that we're focusing too much on corruption, and the word corruption has not been in the statute itself since 1945. But that portion, the malfeasance, misconduct in the performance of official duties, that actually used to be its own offense. If you look at the Olvera case, which both sides cite, and the Elliott case as well. Both of those cite to an older statute that was repealed in the mid-1970s that was actually a misdemeanor, where people in public office engage in some kind of official corruption. And if you had committed that misdemeanor, even if you weren't convicted of it, the law said in the Elliott case, then that fit that. In the Fletchell case in 1967, the Supreme Court refined, and again, this is after corruption is taken out of the statute, that what willful or fraudulent violation means are willful and deliberate acts of oppression and coercion designed to benefit the respondents personally and financially. Again, this is something they leave out of all of their pleadings. And then in Foote, the Supreme Court again said willful neglect, which is what they cite over and over again in their petition and their opposition, means, quote, the intentional failure to act contrary to a known duty. So what Mr. Bailey has to show to even proceed on this is that Ms. Gardner either committed willful and deliberate acts of oppression and coercion designed to benefit her personally and financially, or that she intentionally failed to act contrary to a known duty. The sorts of things that have only resulted in ousters before. Now, in his opposition, Mr. Bailey skips over this entirely. This is his opposition to our motion to dismiss. He tries to analogize this to the existing cases where someone was ousted for office, with him not identifying any new ones, but skips over that all the conduct at issue, all the conduct that was found to justify those ousters in those cases was intentional, and in the prosecutor cases was additionally in bad faith.
Aren't there allegations here, though, that all of the conduct taken by the circuit attorney was willful, therefore I can infer from that that it would be intentional?
No, Your Honor. I'm happy to go through each of the counts, which I think might be prudent. In the prior prosecutor cases, the only two ones, Wymore and Graves, those were prosecutors who were accused of intentionally not filing cases against people, all right? In their opposition to the motion to dismiss, they argue that the other prosecutor cases, of which there are three others that we also cited, I'm sure Your Honor read, the Attorney General still got their day in court based on their allegations, so they should too. The difference there, though, is in those cases, once again, the allegations, the well-pleaded allegations in the original quo warranto petitions were for intentional failures to do something. So, for example, in the Wallach case, it's the intentional failure to file 95 liquor control cases that they specifically identified. That is not what they allege here.
Here, I mean, if you changed the word willful to intentional in their pleadings, would you then believe that their pleadings were adequate?
No, Your Honor, because the only place the word willful occurs in their pleading repeatedly is in its conclusion, that they conclusorily say that Ms. Gardner willfully neglected some duty, all right? But what the well-pleaded facts leading up to that don't allege anything intentional by Ms. Gardner herself at all. They start in count one with an allegation about dismissals. And before I go deeper into that, I'll note that they, on page 52 of their amended petition, the Attorney General has a table of what he says are all the numbers of cases filed by the Circuit Attorney's Office, issued cases for the past 10 years or so. And if you add up all of the ones from 2017 through 2022, so that would be during Ms. Gardner's full tenure so far, that's about 19,300 cases. In their petition, in their amended petition, they identify only 40 cases out of 19,300 where they even allege anything. And in all of those, they don't allege intentional failures by Ms. Gardner. They start in count one with a complaint about dismissals. But all they have are 4 cases where someone else from Ms. Gardner's office made a mistake and the case was dismissed for some reason. Again, and before I go on with that, I want to make clear that Ms. Gardner does not accept any of these allegations. I think it's pretty clear from our lengthy answer that we dispute all of these allegations. Ms. Gardner is not throwing anyone under the bus, what Mr. Bailey calls in his opposition a pass-the-buck defense. That's not the defense. The issue is whether these allegations taken as true fit the statute, and the answer is that they don't. So they start by talking about dismissals, but no intentional conduct by Ms. Gardner. It's not like alleged as was alleged in the Moody case in the 1950s, that she intentionally engineered the dismissals of these cases. There's no allegation of that. They then talk about nolle prosequis in the second part of count 1. They point to 4 examples where there was a nolle prosequi issued. Well, the fact that a prosecutor issues a nolle prosequi, and again, all of those weren't alleged to be Ms. Gardner, they're alleged to be someone else. It's not that she's alleged to have done this intentionally.
Why isn't it a fair inference from what's been alleged that that this is intentional conduct, particularly when you take all of the contents of the whole entire petition together?
Because no actual, no conduct by Ms. Gardner is alleged to be intentional. It's not like any of the prior prosecutor cases. The nolle prosequis, for instance, are much more like the Moody case, where the Supreme Court ultimately said that even an unwise or foolish nolle prosequi doesn't rise to the level of this kind of intentional misconduct. It has to be the intentional failure of a known duty. So unless they have some fact that they can allege, which they don't, that Ms. Gardner engineered this for some reason, that doesn't meet that standard. That's not that high burden. The same thing with the failure to writ defendants. And I'll remind the court that in Foote, again, this is a recent decision from the Supreme Court, the Supreme Court says that the mere violation will not support a judgment of ouster. They have to show more than that, just that some duty was violated. They have to show that Ms. Gardner intended for that duty to be violated. And that's not something the court can infer because there's no extra conduct from which that can be inferred.
Is it your understanding, as it is mine, that the kind of the question of what conduct is intentional versus negligent or otherwise is typically a question of fact?
Once there have been allegations that meet that initial hurdle, they haven't met that initial hurdle yet. All they're alleging is effectively neglect by other people besides Ms. Gardner. That is not, as the Supreme Court confirmed in Foote, enough to allege an intentional violation of a known duty to subject someone to an ouster case. The same thing with speedy trial or failing to prosecute in associate circuit cases. What they're doing is they're plucking out select cases from 19,300 showing that something went wrong and then trying to say, well, now you should infer from that that Ms. Gardner engineered that. There's nothing in their petition that suggests she did. So that isn't enough either.
What do I make of the allegations that all of these specific examples are part of a larger pattern in practice?
Well, they would have to show that pattern in practice. They, you know, in their petition, they say that this includes but is not limited to. Well, you can't have any well-pleaded fact petition. This includes but is not limited to. You have to show your cards. You have to show what you believe fits this standard and what they've alleged does not. And even if there's some kind of extra pattern, that would be a pattern not again of any intentional thing. They don't get over the first hurdle of saying that Ms. Gardner has intentionally done something wrong. It's like the prosecutors with their friends in the gambling industry who, you know, in the Wymore case, who doesn't want to prosecute his friends in the gambling industry.
Well, and a lot, you know, those cases certainly are you know, very specific. And I guess part of what I'm wondering is whether, you know, that sort of conduct is necessary. I mean, it certainly is sufficient for an ouster, but is it a necessary type of conduct?
It is
the corruption, the I'm on the, you know, the assumption that the prosecutor's on the take, that sort of thing.
Well, in the Wallach case, the Supreme Court said where there was no corrupt or lacking in, there was no evidence that the prosecutor was corrupt or lacking in integrity, nothing to show evidence of a corrupt motive. That was one of their reasons for saying that, well, so he didn't file cases against 95 people. Unless you can show that it was done for some corrupt intentional reason, then you don't get to the point of 106-220.
And that, again, I mean, in that case is a case that was done, that decision is made after evidence has been taken by a commissioner of the Supreme Court.
Right, but again, that was because their initial petition, if you read the Supreme Court's opinion, it recounts what the allegations were, was that he intentionally had done that for some corrupt reason. And of course, then it went to a hearing. What the Attorney General is lacking, I mean, they're the ones with the burden here, right? What they're lacking is any authority supporting the use of 106.220 in a circumstance like this, because none exists. We cited, and they certainly don't add any new authority, we cited every case where this has ever been done. They cite nothing where the subordinates of an officer were accused or alleged to have failed some duty with no allegation even that the officer herself knew about this, let alone engineered it, but the official was ousted. They try to use two cases in their opposition. Williams, which is from the Supreme Court in 1939, that was the sheriff cognate to the Graves case from Jackson County, and Orton from the Supreme Court in 1971 for the notion that a subordinate of the officer negligently failing a duty is enough. But that's not what happened in those cases. In Williams, again, that's the Jackson County sheriff in the 1930s helping out the Pendergast regime, and the Orton case, which is the Pemiscot County sheriff in 1971, those folks were ousted, not because some deputy failed to arrest somebody, but because the sheriffs themselves intentionally failed and refused to enforce laws. The word intentional is effectively missing from their entire vocabulary. We addressed the standard. They don't address the standard at all, and that's the standard.
Well, the word intentional, though, is also missing from the statute.
Willfulness is intentional. That's what the Supreme Court held in foot.
And if they've alleged in their petition on numerous occasions that this conduct was willful, is that not the same as alleging on numerous occasions that this conduct is intentional?
If they simply had said this conduct was intentional as opposed to willful, I'd still be here arguing in front of Your Honor. Because, again, those are conclusions, not well-pleaded facts. And under the Missouri's a fact-pleading state. You can't just say, she intentionally did this. She intentionally, the way they phrase it is, she intentionally violated some duty, and then not plead any facts to actually show that she did. It's the absence of those well-pleaded facts that's what bring us here. If this had been something like in the Wallach case, where they alleged she specifically, for some intentional reason, did not file 95 cases against these individuals for some corrupt reason, then that might well be enough. But here, I'll note, despite arguing about discretion, the Attorney General doesn't actually argue that Ms. Gardner has refused. Again, it has to be some kind of actual refusal. It's an intentional refusal of a known duty. That's what willful neglect is, the Supreme Court says. They don't actually allege that she has refused to file any cases. In fact, in one of their counts, I think it's count 3, they say, count 2, that there's a backlog of 1,200 cases awaiting review and 3,500 pending warrant applications. There's no allegation that Ms. Gardner has refused. In fact, by their own language, they're pending. They're awaiting review. Maybe things are slower than the Attorney General would want, but the Attorney General doesn't control the office. And in the Wallach case, the Supreme Court said just because the Attorney General and the county prosecutor or the circuit attorney may have a difference of opinion about that, does not make for a claim for ouster. I'll note, though, also, Your Honor, there are a series, and this isn't something we put in the motion to dismiss, but it's worth considering. There are a series of allegations in their amended petition that were from Ms. Gardner's first term and not her second term. I would submit that any allegation that was about something that was before 2020 isn't really properly to be considered. Because, for example, if the Attorney General were actually to win this, and Ms. Gardner were somehow ousted by the court, she could run again. The fact that something is alleged in a previous term, and I'll note everything involving the Xavier Uzanga case, those are allegations from 2019. That might be the only thing that comes close to arguing that, or alleging that she refused to charge someone, although even then it doesn't, it just says she didn't. That's not enough. That's not a willful and deliberate act of oppression. It's not an allegation that she intentionally failed to act contrary to a known duty. The same thing with officer-involved shootings. They don't allege that she refused any of those. They allege that she merely, quote, has not made decisions about whether to issue or refuse charges. That's not the willful, intentional violation of a known duty, even taken as true. I do want to address, because a lot of their allegations, certainly the Sunshine Law allegations in count 7, the discovery allegations in count 4, the failure to keep victims informed allegations in count 9, those are all about Ms. Gardner's subordinates, and they even say so in their amended petition. In our opposition, again, we're not saying that any failings of the office are due to subordinates. Far from it. Ms. Gardner is very proud of her staff and the hard work that they do for the people of the city of St. Louis. The issue is whether those allegations are enough to oust Ms. Gardner, the allegation that someone else in her office failed in a duty. The Attorney General doesn't have any authority where that actually happened, where again, they try to do this with Williams and Orton. Those cases don't actually say that. Those are sheriffs refusing to charge people intentionally. What they do, though, is they try to use vicarious liability from other sorts of civil cases and try to, a respondeat superior kind of argument, and say that, well, if one of her if one of her staff does something wrong, therefore that inures to Ms. Gardner, and that is grounds for her own ouster. First of all, that fails the strict liability. That fails the strict construction of the statute. In Foote and all the other cases we cite, the Supreme Court says the statute is to be strictly construed. And it says if the person has willfully neglected a duty, has willfully or fraudulently violated a duty, then the person can be ousted. That's not an example.
And I come back, I guess, to the kind of the broad standard that we ultimately have here on a motion to dismiss, where I'm supposed to assume that everything in the petition is true. I'm supposed to make inferences in favor of the non-moving party here. And so, I mean, to what extent then, if they're alleging that, if the petition, specifically alleges that respondent did X, I'm supposed to, how do I get around that particular allegation to say, well, actually what they're alleging is that respondent's superior subordinate did this?
Well, most of the time the allegation is directly there in the petition, that it was an assistant circuit attorney who did this, or an assistant circuit attorney who did that.
Is the inference that it's fair that if Ms. Gardner's subordinates are doing something, it should be at her direction, as opposed to the opposite of that, like they've gone rogue, they're working on their own?
That's supposition. Well, first of all, it's supposition rather than an inference. An inference has to be something drawn directly from a fact, not stacked on other inferences.
Well, the inference would be that if an assistant circuit attorney has taken an action, that it was taken in accordance with Ms. Gardner's duties.
Well, again, it would have to be that Ms. Gardner intended for that result, right? That's what they would have to argue. So the one case that they point to where there was something about a deputy, it's the Foote case itself from 1995. There, that was, actually I take it back. It's another one of the, it's Nixon versus Russell. So this is the sheriff who intentionally failed to keep an inmate charged to his care confined in jail and let him out earlier. There, one of the defenses by the sheriff was, well, I thought that by my deputies doing that I was obeying my duty. But the difference there was, again, he intended for that to be the result. Here, there's no allegation that Ms. Gardner intended for discovery to be violated by her subordinates, that Ms. Gardner intended for people not to show up to court and therefore have cases dismissed, or any of the other 40 examples, or if that they come up with. There has to be that nexus. So there has to at least still be some intentional conduct alleged by Ms. Gardner, and they don't get there. But moreover, they don't even allege, if it were vicarious liability, it would be the same standard of intent against the lower officer as it would be against the higher officer, right? That one transfers to the other. They don't have any allegations that even the assistant circuit attorneys intended for bad results to happen in these, less than 0.2% of the cases that have been done in Ms. Gardner's tenure.
If we're reading the allegations broadly, as I have to do, Isn't there kind of this general allegation from the Attorney General's office on each of these counts that there is a duty to do something, a duty to prosecute, and that Ms. Gardner has willfully neglected her duty to do so, and then their evidence of that is, that there have been a lot of dismissals, the number of cases that we're talking about. I mean, it seems that if we look at it really, if we get down into a granular level on all of this, it's harder than if we look at it at the allegations more broadly, as really I'm supposed to be doing on a motion to dismiss.
Sure. Their evidence of willful conduct is non-willful conduct. I mean, what they have to show is something more than that. In every single other ouster case, every single one where an ouster was successful, or where it went to a hearing or a trial or something like that, there has been a specific allegation about the intentional conduct of the public official at issue. Simply concluding that they willfully, intentionally violated some duty, but then showing facts that don't actually show that they willfully or intentionally violated a duty was not there.
Isn't kind of the mental state of someone necessarily something that you have to allege and prove by circumstantial evidence?
It certainly can be alleged and proved by circumstantial evidence, but they haven't alleged it. All they've done is stated conclusions. They haven't stated a single allegation against Ms. Gardner that she intended for any of these outcomes to happen. They have to have something more. They have to have the connection to organized crime, like in those old prosecutor cases. They have to have the young, inexperienced prosecutor who is letting his friend off with the nolle prosequi, like in the Moody case. They have to have any of the other well-pleaded facts that were shown in these other cases, and they simply don't get there. The law of Missouri demands more. Just making conclusory statements that Ms. Gardner willfully violated or neglected some duty is not enough. Missouri's fact pleading, that might work in federal court, but that doesn't work in this court. This is an attack on the democratic process by someone who was never elected. And if Mr. Bailey doesn't like the job Ms. Gardner is doing, that's his right. That's his First Amendment, his right under Article 1 of the Missouri Constitution, and he can support a different candidate at the next election and hope the people of St. Louis agree with him. But the law of Missouri doesn't allow him to do what he's trying to do here and use this court to oust Ms. Gardner for stuff that he disagrees with, not on these allegations.
Thank you, Mr. Sternberg.
Thank you, Your Honor.
May it please the court.
Counsel.
Mr. Sternberg and Ms. Gardner would like to talk a lot about what the petition doesn't plead, but she doesn't want to talk a lot about what's important under the statute, what duties she has failed or neglected. And there's a replete throughout the amended petition. There are assistant circuit attorneys not showing up in court and having cases dismissed out from under them. There are assistant circuit attorneys unprepared in court and nollying cases on the eve of trial over and over again. When we talk about 19,000 cases, if you add up all the case numbers during Ms. Gardner's term in office, the amended petition pleads that there were 2,700 cases dismissed by the court. A majority of those cases were due to Ms. Gardner's failure to either prosecute those cases, turn over discovery, or comply with speedy trial requirements. There were another.
I think, sorry to cut you off, but I think that let's get down to kind of the big crux of the issue, which was a lot of Mr. Sternberg's argument was, what's in the petition that allows me to make an inference that this conduct was intentional as opposed to just negligent?
Well, the quo warranto cases, contrary to Mr. Sternberg's reading, are replete with cases where the neglect of duty, willful neglect, is shown by when a public official knows that they need to do more and fails to do more. So the Olvera case was about a recorder of deeds who swore that certain financial transactions under oath were correct because that's her duty under office. And she argued that many of those entries, she did not know that they were wrong. And she changed one entry believing that she was correcting a mistake, that she was always acting in good faith. And the court granted summary judgment against her, finding that it didn't matter her subjective motive, her excuse for why she failed her duty. What mattered is that she was required to do more to verify that those entries were correct, and she didn't do that. That's what's going on here, and the petition is replete with examples that can show a repeated pattern of conduct that Ms. Gardner should have known to do more to complete her duties and failed to do more. That she should have known that her assistant circuit attorneys were failing to notify victims, failing to keep up with discovery, failing to try cases on time, failing to show up for court, failing to be prepared. and that she has to complete those duties. And the Williams and the Orton cases, they're clearest evidence of this kind of conduct. So one thing that the quo warranto cases have going for them is that most offices aren't as large as the Circuit Attorney's office, and most officers are more personally involved in their day-to-day duties. Obviously, Ms. Gardner does not try any cases that I know of and doesn't appear in court, but she is still responsible for making sure that all of those cases are prosecuted, for making sure that victims are notified, and for making sure that all of those things are done. Just like the sheriffs in the Williams and Orton case were allowed to rely on the local police to enforce the law in Kansas City or in the city that they lived in. But once they found out that the job wasn't being done, it's as if the police force doesn't exist. The sheriff has an independent duty to enforce the law when he knows it's not happening and he needs to do more. The same is the case here. The petition shows, beyond question, that Ms. Gardner should have known that she needed to do more, that her job was not being done, and in that case, it's as if her assistants don't exist. If they are not doing the job and getting it done, then she has to do more, and whether that's hiring more assistants, more effectively managing her office, or appearing personally to take cases. The duties of her office are her duties. They are not her assistants' duties, even when she delegates a task to them. Maybe the clearest example of this is in the Foote case, where the sheriff was accused in one of the quo warranto counts of filing a late report. He had a statutory duty to file a report on time. He filed it late. His excuse was that he assigned the case to a subordinate and they hadn't gotten it done on time. And the court said, that is a neglect of your duty. And while it's not enough by itself to show willful conduct, it was considered along with the rest of the quo warranto cases as evidence of neglect of duties. And the Russell case, Nixon versus Russell, is the same. There are repeated acts of neglect, and when they're added up, they show that the official should have known to do more and should have done more to complete their duties. And that's the definition of willful neglect. When you repeat a process that isn't working over and over again, your intentional failure to do more is willful neglect. That's what the case law says, and that's how the petition establishes it.
So I have one thing that I'm wondering about your petition is that there are 10 different counts. And part of my question is, you're asking for one remedy, removal from office. Are these counts independent of one another? Do they all act together? Is it some of them are like, well, maybe that one's not good. I can knock out a count here and there, or does one depend on the other?
They all could independently require the circuit attorney's removal, but the case law has a lot of discretion in the removal process. We give a lot of trust to our public officials, and a lot of times they get a lot of leeway. And that's why the Attorney General has discretion in whether to seek quo warranto, as do local prosecutors. And this court ultimately has discretion to issue the writ if you think it's in the interest of justice or not. I forget the name of a case, but there was a case where an official was, quote, just for sometimes doing work that wasn't of the office while she was on the clock. And the court found that she fulfilled all the rest of her duties. There was no argument that she was doing a good job in office, and the quo wasn't appropriate in that case. But that won't be what the case is at the end of this case. The Attorney General, as pled in the amended petition, will show that these repeated failures to do Ms. Gardner's duty require it to be in the interest of justice to remove her from office.
Why is there an inference to be made from the petition that this was intentional dereliction of duty as opposed to just the way that Ms. Gardner decided to exercise her prosecutorial discretion?
I have two answers to that. So first, while Ms. Gardner would like the standard to be that she intended the ultimate result, that something bad happened as a result of failing to do her duty, that's not the standard. What ultimately matters under the statute is whether the duty was failed or the duty was neglected, whether the job was ultimately performed, and what the official knew or should have known about that, which the case law shows can be proven indirectly. But the second answer to your question about prosecutorial discretion is that most of the counts that we've pled here don't deal with prosecutorial discretion at all. Prosecutors don't have discretion to not show up in court for trial and have the case dismissed out from under them. That's not a discretionary duty. Prosecutors don't have discretion to keep victims informed of the status of their case. That's a constitutional right of those victims. It's not a discretion given to the prosecutor. Same with compliance with the Sunshine Law and the other statutory duties. While we have pled one sub-count of count one that's about Ms. Gardner's choice to nollie cases, and a couple sub-counts that are about reviewing and charging cases, discretion is not absolute. It's very clear from the prosecutor cases, both the 2 where the prosecutors were removed and the 3 where they weren't, that the court will look into the discretion in quo warranto cases to see if it was faithfully exercised, that using prosecutorial discretion is just another duty of the job. And like any other duty, it too can be misused incorrectly. Like the case, the 3rd case where the prosecutor wasn't removed, it's slipping my mind at the moment, but in that case, it was 1 nollie and 1 decision to charge a defendant that they were talking about in that case. And they heard testimony from 10 witnesses and made the prosecutor explain his reasons for not nollieing the case. So it's clear from the case law that discretion is certainly not absolute, and just saying that I'm using my discretion is not enough to get around a suit in quo warranto. And so while we've
Could
talked
you address the question about you're not alleging necessarily that Ms. Gardner has taken any actions, but that her subordinates have taken a number of actions for which you're now trying to hold Ms. Gardner liable?
Yes, that's true, Your Honor. So we've talked about the part of the statute that's willful or fraudulent violation of your duties, some sort of personal enrichment or attack on someone. That's not the kind of oppressive act that we've alleged in the petition. Most of the counts allege that it was a willful neglect or a knowing failure, which as far as I can tell are pretty similar standards of proof. But when you talk about neglect and failure, obviously inaction is what we're talking about, not any particular action. And so the failure to accomplish the duty is what's at stake there. And it's clear that Gardner holds all of those duties. The Williams case says that a public official holds their office cum honore with the burden of all of the responsibilities of the office. And the Williams-Norton case made clear that dereliction of other officials or other people who have duties in the same sphere does not excuse an official's failure to do their own duties. So when we're talking about Ms. Gardner's assistants, their only duty under the statute is to assist her in accomplishing theirs. So if they fail to accomplish the circuit attorney's goals, the circuit attorney has failed. She directs and controls them, is what the statute says. So not only should you assume that their actions are under her power, that they're directly her actions, but we've pled, as a matter of fact and as a matter of statute, that Ms. Gardner directed and controlled her assistants in the course of their duty. So if they've done something in the petition, it's a fair presumption that it was at the direction of Ms. Gardner or under policies that she controlled that caused them to act in the way that they acted. And that extends to caseloads, of course. If you assign someone 500 cases, when you assign them the 501st case knowing that they can't possibly prosecute that case, you're not fulfilling your duties. If you give it to someone that in good faith could do it, then that might be a way to defend against a quo warranto action. But assigning cases to people who can't get it done because of the way you've managed your office is exactly the type of willful neglect and knowing failure that the statute is talking about.
How do we draw the line here between duties that are being done poorly versus duties that are being willfully neglected?
Well, in every individual case, a duty could be a failure. So, for example, in the Foote case, they had some number of cases where they were holding defendants for too long on bail. Obviously, sometimes they bailed defendants. Similar in the Wymore case and the Graves case, they weren't prosecuting gambling offenses, but they were prosecuting other offenses. They were carrying out the duties of their office. So if the duty was in one particular area, then you could point to, then maybe it would be limited to that area. But the circuit attorney's duties are broad to prosecute all the cases in the jurisdiction. So when her office shows up and fails to prosecute a case, it's just what it says. She's failed to prosecute. It's not discretionary to show up in court unprepared and to have the court dismiss the case out from under you because you're not ready. That's not doing your job. That's not just using your discretion. It's failing. That's what it is. And if you do it enough times and you don't take any steps to stop it, it's knowingly failing. It's willfully failing. There's no other result that can happen when you keep taking the same actions and keep getting the same results. And these patterns, as the petition shows, it's not as if it was isolated incidents. We've alleged a pattern spanning some 11,000 cases, and that's just dismissals and nollies. We're not even talking about, most of the counts don't even talk about cases that went to a jury verdict. We're mostly talking about failures before it even gets that far. So those cases don't involve the use of discretion when what you're talking about is doing the same thing over and over again and failing in a way that's not excusable. So that's the heart of our petition here, is that the circuit attorney's duties are hers, and they're not getting done. It's as simple as that. And the question is, does she know about that? And is there more that she can do? And we're going to prove that in several ways that are pled throughout the petition. These failures are public. They're known, like the cases with the prosecutors from the 40s, Wymore, Graves. Those failures that they had were notorious and open. Same here. There are cases that are matters of public concern that are going handled incorrectly, and that's as pled in our petition. There are patterns that span all of these cases repeatedly. That's like the Russell case and the Orton case, where they say repeated neglects of duties, even simple neglect, can add up to a knowing or willful neglect, a knowing failure to perform your duties. So the petition pleads those facts, and it pleads that Ms. Gardner directed and controlled her assistants in their actions as she's legally required to. And those actions that her assistants have taken or not taken, the court has to presume that they were according to a policy, practice, or direction of the Circuit Attorney's Office. If they keep doing something over and over again, then the case must be that it's been decided they should do it that way, or there's a pattern of failure that's never been fixed. And either one of those is willful neglect.
I mean, if I look at these allegations and I feel like, well, ultimately you're really just alleging, negligence on the part of the circuit attorney, that I don't think you're suggesting that would be enough to get us to even a trial here. That if it's genuinely negligence, if it's just she's not doing a good job, there has to be more than that. You'll agree with that.
I do. Certainly one act of negligence would not be enough, right? So if a circuit attorney didn't show up for a status conference, that happens. I think that's happened to probably every lawyer. Now, if I pled in the petition that over 11,000 cases, circuit attorneys never show up at status conferences, that's a failure. You can't assume that that was a mistake when the broadest intendment is given to the pleadings. A pattern in practice suggests more. And while we've only given...
The intention, I can infer intention, you're saying, because of the volume of alleged failures.
Yes, that's the Russell case directly. They say, while any of these one acts of neglect might not be enough to require their official's removal, repeated instances of this conduct are enough. So that's a matter of case law that intention in these cases can be inferred from repeated practice. And it must be that way because the statute is set up to protect Missourians from officials who knowingly and willfully over and over again fail them in their duties. It's not about honest mistakes. It's about a pattern and practice of failure. And that's what this case pleads, and that's what this case will prove at trial. Thank you, Your Honor.
Thank you. Mr. Sternberg, you have a response?
A couple of things Mr. Crane just said aren't correct. He said that the definition of willful neglect is when someone knows they need to do more but fails. That is not the definition of willful neglect. The definition of willful neglect is intentional failure to act contrary to a known duty. This notion that there are any cases where a public official was ousted from office, actually ousted from office because of repeated failures by their subordinates without any intentional conduct directing that by the official is simply not true. The Foote case...
it seems like there's some mention of a standard similar to that in some of the sheriff cases, particularly some of the ones with the, hey, we thought the police were doing it.
The difference is, what those cases are about, and I'm glad you asked that, Judge, those are about ongoing conduct, that the sheriff in those cases knows that ongoing there are these failures to obey duties by his subordinates. And he says, okay. That's not what they're alleging. They're alleging that there were past failures, that there were 4 cases that were dismissed, that there were 4 cases that were no-lead in some manner. But then they say that Ms. Gardner had some duty to do more with what cases that were already over, that wasn't ongoing conduct. That's what those cases mean. In every single one of these, and I'll note in Foote, which is one of the sheriff cases, that was a sheriff who misrepresented the number of police vehicles purchased for his personal gain. That's what ultimately really was his ouster. They said, yes, there's other examples of failures of duties during his time. That's not what actually got him ousted. It was detaining prisoners unlawfully and then basically stealing from the till. They haven't alleged anything like that of Ms. Gardner. This notion that you can show, so what if the circuit attorney's office, what if this wasn't St. Louis? What if it was Chicago, a really big city? And instead of, he said, if you show 11,000 failures, What if there were 300,000 cases a year, and over the course of 7 years they could show 11,000 failures? Does that show intent? I think it's proportional. Here you're talking about retrospective conduct. So Ms. Gardner sees that some circuit attorney didn't do their job, right? There's no allegation that she intended for that to happen. There's no allegation that she engineered that to happen. In fact, quite the contrary. What they're trying to do...
I think as I understand what their argument is that, well, the volume of things here should allow us to bring, that we believe that it's intentional as a result of the volume, and so ultimately, Judge, what we should do is have a trial and determine whether it is in fact intentional.
But they don't have that. They don't have any well-pleaded allegations of that volume. All they have are 40 cases out of 19,300. They say that, conclusorily, that 3,000 cases were dismissed, the majority because of some failure. Well, then show them. That's not a well-pleaded allegation. That's a conclusion. There has to be specific facts, and that's not enough. And I do want to mention, while I'm on that, Your Honor, you asked Mr. Crane whether the counts are independent or whether they're all interrelated. I would encourage the court. I mean, I think it's part of the court's duty in a proceeding like this to determine which of the counts actually, if any, do state this. And if the court finds, again, I would disagree, of course, but if the court finds that one or more of the counts are sufficient but others aren't, I think it's part of the court's function under the motion to dismiss rule that the court dismisses those counts that don't succeed.
Well, and actually that kind of raises an interesting question for me, which is, this is pleaded as a motion to dismiss, and I've already issued a preliminary order in this case, and so my question is, whether you think I should be dismissing the petition or quashing the preliminary order.
That's a very good question. So writ procedure is a little odd. I mean, I appreciate that. Rule, I think, 9806, which is about what happens after the preliminary order, is basically says that the preliminary order is a gatekeeping function, right? It's the court saying, I found that you have met the requirements of the statute and the rule, and therefore we're going to court. And the next step, I think it's 9806, says that we then have to file an answer and any other motion, and that the rules of civil procedure generally apply. No, I think the correct law on that is this becomes like any other civil lawsuit at this point. It's subject to, I mean, the only weird rule was we had to file an answer and a motion to dismiss. Ordinarily, I would have just filed the motion to dismiss and not wasted time with the answer until the time came if the motion were denied. But here, no, this is like any other civil lawsuit. It can go to summary judgment, it can go to trial, and it can be subject to a Rule 5527 motion to dismiss, just like we've brought. And I think the law on that's pretty clear. In fact, if anyone has violated the rules in this, it's the Attorney General by not filing suggestions in support of their amended petition, which the rule really did require. That might have enabled us to have a more cogent discussion about this.
Well, I mean, I guess they moved to amend the petition, but they had already filed suggestions in opposition with their original petition.
No, suggestions in support of their...
Yeah, well, sorry, I mean, but they had already filed suggestions in support of the original petition, then they moved to amend the petition itself, so...
The suggestions would, but that only applies to that petition, not the amended petition. I'm not saying that's a reason that this should be dismissed or stricken. I'm just suggesting that wasn't terribly helpful for the parties. One thing Mr. Crane said, and this is also something he put in his opposition to our motion to dismiss on page 11, is that there's an allegation that Ms. Gardner assigned cases to people knowing that they will fail. That's not pleaded in their amended petition at all. He just suggested that as well here, that she assigns 500 cases to a person knowing that they'd fail. I don't know about you, Your Honor, but I've seen plenty of public defenders who have 300, 400, 500 cases, and they seem to do fine.
They don't seem particularly happy about it.
Perhaps not. Perhaps not. But it does happen. The point is that that's, simply that is not, well, the problem with that is that's not actually an allegation in their amended petition at all. That, she set people up to fail. That might be some form of intentional conduct. But the reason they don't allege that is they have no facts that they can allege that with.
Is that just a different way of saying that I think they have alleged that the circuit attorney has willfully understaffed her office?
Well, they say she's understaffed her office, or that her office is understaffed, and then later they say that therefore she willfully failed a known duty. But there's no allegation that she intended to understaff her office. There's no allegation that she took some action that was designed to understaff her office. It's a hard hiring environment. I mean, there are all kinds of other reasons for that. But they have to show something more than something that could be inferred to be a mistake or something with which the Attorney General simply disagrees, which is what most of this seems to be, especially his argument or his count about the use of finances. There's no argument that Ms. Gardner was like that sheriff stealing from the till, or like the assessor or collector in Olvera, actually changing numbers in account books. The allegation is that they don't like the way she spent some of her money. They wish she hadn't hired some outside counsel that she did. But that's entirely within her discretion. There is no case law that says that isn't. And while we're on Olvera, Mr. Crane suggested that Olvera dispenses with the notion of intentional conduct because the collector there said that her conduct was mistaken. But she had admitted, and this is what got her ousted, which, I mean, her plain admission was resulted in summary judgment, that she intentionally had changed numbers in the books. The obvious inference was she was taking in $100, only recording 10 and probably keeping the rest. But that, again, is nothing like the allegations here. They simply have no law that says what they have alleged, the sort of thing they've alleged, is sufficient for ouster. Ouster requires a great deal more. Our democracy requires more. We ask the court to dismiss.
Thanks, sir.
Thank you, Your Honor.
Any further argument?
Is there anything you'd like to hear from?
I'm set. Thank you. All right. So the Mr. Sternberg, I'm going to give you 7 days to file a reply on the motion to dismiss, and then it will be taken under submission. My intention, if you get that to me in 7 days, is to have a ruling to you very quickly, though. You understand? All right. So then the next motion is the motion to stay discovery. I assume you still want to stay the discovery. Do you want to argue that?
May it please the court.
Yes, sir.
Judge, the issues with regard to the motion to stay are quite straightforward. As you can tell in this case, we believe that the allegations against Ms. Gardner were not properly pled. The discovery the pleading itself is over 620 paragraphs. The discovery we've received to date is incredibly onerous, including there was an amended subpoena duces tecum filed and served on the CAO, the Circuit Attorney's Office, that has, I believe, 59 document requests attached to it. We believe it's appropriate, first of all, to make sure this case is going to go forward, and second of all, to know the scope of what's going to go forward before the parties actually start proceeding with discovery. We are very hopeful that this court will dismiss the entire case. If it dismisses even a large portion of the case, it will substantially reduce, hopefully, what discovery Ms. Gardner and, frankly, Ms. Gardner's employees need to respond to. And also, presumably, it will very much narrow what discovery Ms. Gardner will propound upon the Attorney General. So we just believe as a realistic thing that the discovery should be stayed until we know what pleading is active and what the scope of this case will actually be.
Thank you. Any response to that?
Your Honor, may I please the court?
Counsel.
There is no discovery that's taking place in terms of depositions until early May. We've scheduled a deposition of the Budget Office. This court has never issued an order staying discovery. They allude to that. This court has not. There's reasons for this matter to be expedited. We'll get into that in a bit. But I talked to Mr. Downey before this motion hearing. He told me he was going to argue that the motion to stay was subsumed within the motion to dismiss. I guess he's changed his mind on that. I would argue the motion to stay is subsumed within the motion to dismiss and that that motion is essentially moot. Thank you, Your Honor.
Thank you. I'll take that under submission. All right. I think we'll take up the discovery motions, and then I'll kind of do a general case management conference, at which point in time we can kind of get into the motions to expedite and those sorts of things. How about we do the motion to quash? Is everybody, Sherry, you okay? Yeah, free? Yeah. Okay. All right, we'll go ahead and take up the motion to quash filed by the CAO.
Thank you, Your
Can
John
you
Jeffers on behalf
clarify?
of
Sorry, Mr. Jeffers. Before you get started, can you just clarify for me who you represent, which of these subpoenas are still active, and which ones you're trying to quash?
Yes, Your Honor.
Thank you.
I know there was a series of filings on this. We represent the Circuit Attorney's Office. There were several subpoenas directed at the Circuit Attorney's Office, and then there were also subpoenas directed at individuals employed by the Circuit Attorney's Office who I do not represent. But insofar as they are calling for office property that those employees only have in their official capacity, we would request or move the court to quash those as well.
Okay.
Your Honor, I think in the interest of judicial economy, I think the simplest position right now is exactly what Ms. Gardner's counsel just took, which is that we should await the court's resolution of the motion to dismiss to see whether the court will narrow the issues or dismiss the amended petition entirely, because a burden both on the court and on the recipients of the subpoenas to respond to this would be immense. And I think if the amended petition does survive, there could be further discussion with the Attorney's Office, there could be protective orders and so forth. If it's gone, obviously the immense burden of these subpoenas never needs to be visited upon either the employees or the office. So in the interest of judicial economy, Your Honor, we would say that we should just await the resolution and then come back at that time.
Okay. Have you had conversations with the Attorney General's office about what you would be willing to produce, or any kind of specifics regarding some of the, there are 59 requests in the most recent? Have you had conversations with the Attorney General's office, or has your position been we're not going to turn over anything?
No, Your Honor. We did meet and confer with the Attorney General's office just last week. They talked about a protective order. We said, look, if we're in a position where this case is still a live matter, then we will certainly engage with you on an appropriate protective order. The subpoenas that they have served are breathtaking, both in scope, but also in terms of the information that they would ask the Circuit Attorney's Office to produce regarding crime victims, regarding law enforcement informants. And we're talking information that is very, entitled to the most protection, and that is entitled to the most sensitivity, and that could only be produced with a very robust protective order. We've told them that, and I think we all put a pin on it and said, we'll meet and confer about this if we end up in a position where the office has to respond to these requests.
Okay. Mr. Corrigan, I see you shaking your head there. Would you like to address that argument?
The only thing I'd like to address is the misrepresentation that was just made to this court. There's no discussion, not a single discussion, about the Circuit Attorney's Office turning over any documents. We raised the issue of a protective order. We've been asking for documents since March 1. We don't have a single document, nor has one ever been offered. So what he just said is incorrect.
Your Honor, I think what I just said was that I said if this matter survives, we will meet and confer further. We did meet and confer before. Start looking at an appropriate protective order for something like this. But my position here is exactly what Missouri Rule 58.02E2 states, which is that upon an objection from a party, we would not have to respond to the subpoenas until further order of the court. And that's right there written into the rule. So if Mr. Corrigan has a problem with that, I think he has a problem with 58.02E.
Okay. Well, we're all here. You've flown in. The motion was noticed for a hearing today.
Correct.
Would you like to talk about it?
Well, Your Honor, if we do have to get into it, yes. I think, as I have said, what 58.02E requires us to state specific objections to the scope of the subpoena. The subpoena has many, and we have done that in our motion to quash. We've invoked numerous.
So I guess one of the things is you've kind of asserted a blanket privilege objection, and the problem that I have with some of that is that it's hard for me to make a really informed decision regarding what's actually privileged and what's not privileged, and what you need to turn over and what might be a closed record, and whether they're entitled to discover closed records, being as they do represent the state. So
sure.
Why is I guess there's been an objection made, and I question whether how specific that objection was actually.
Well, Your Honor, if the amended petition survives the motion to dismiss, we would be happy to do what I do not think what goes well beyond what the rule states, and go through each of the requests and say exactly what our objections are to each of those requests. There are several of those requests that, as I have noted, calls for information as sensitive as the identity of confidential informants, communications about witnesses, communications about victims who have done nothing other than try and put violent criminals behind bars. I mean, ultimately, what they are doing here by forcing the office to disclose that kind of information and the immense amount of manpower that would go into that is really undermining public safety. It totally defeats the purpose of what they say their amended petition is for. So, you know, if we get to that point, if the amended petition survives, I'm perfectly happy.
I think that for purposes of our conversation today, that we should assume that the amended petition will survive, and if I decide otherwise later, I can enter an additional order, limiting the scope of what actually needs to be produced. But what I'd like to do is talk about some of these objections so that we can get this, show on the road, so to speak.
Okay, Your Honor. I mean, some of them call for, relatively non-controversial kinds of information, like an office organizational chart, some things like that. That I think if we were in a position where we had to respond, those things we could produce. Others call for information that are protected by a number of different privileges, a lot of which I have just alluded to. I think ultimately the court would have to litigate those issues. I think, for the purposes of judicial economy, it would be best to wait and see what the petition looks like.
Well, let me ask you this question. If I was to tell you to assume, that we have a petition that's filed, it's the operative pleading here, and that all of the allegations are going to stand. Would you be in a position, there's a room across the hallway here, would you be in a position to go and talk to the Attorney General's office and whittle down some of what the issues are that we need to address?
If they're willing, yes, Your Honor.
Would you all be willing to do that?
Of course.
All right, well, here's what we're going to do then. I'm going to send you all across the hall. I want you to go through the petition and figure out what it is that you actually might be able to produce, what you have objections with, and then we can have a more informed discussion as to kind of the scope of what needs to be resolved, and what we need to put a pin in.
Okay.
Is that okay? All right, the court's going to be in recess. If you'll let the bailiff know when you're all ready to proceed, he'll come get me and we'll come back up.
All rise. How long will it be?
So they're done. Okay.
Your Honor, did you have a time frame in mind? How long? Be respectful of the court's time.
How long do you? I got an office back here. I can keep plugging away. How much time do y'all need?
Judge, I'm hopeful we can get you an answer here pretty quick.
About 20 minutes? That
sounds great.
Perfect. Let's do 20 minutes.
Perfect.
Thank you.
Ceremony courtroom will be in recess for 20 minutes. You may leave the courtroom, please. Ladies and gentlemen, make sure you leave something in your chair to identify your seat when you get back.
They just told me about possibly doing a pool interview up here.
Oh, okay. Well, then that's probably.
That's what
so you would
Lauren said.
Okay, okay.
But
that's what I was going to ask if me and Mary are going live, and it was downstairs outside, which is I went last.
Well, just if
it's up here. Okay.
I'll come down as soon as I get packed up. I mean, if this goes into tomorrow, I don't know if I'm supposed to leave my shit taped up. So, yeah, just let me know.
guys have anybody that's outside taking a cigarette break, you better take it back up. We'll close the doors. The ceremony courtroom is now back in session. Ladies and gentlemen, please be seated. Double check your cell phones, please.
Well, that was a very long 20 minutes, counsel.
Well, we had long conversation.
Well, that's good. That makes me hopeful. Where are we?
Your Honor, we'd like to put on the record, I think, point by point from our subpoena to the Circuit Attorney's Office, their answers so far. And so that there's no arguments later, Your Honor, that we can come back to and say, yes, they agreed and when they didn't. So that we're all on the same page at this point. Your Honor, I'm just going to be saying the number of our request and then their answer. That will hopefully speed things along since we'll be looking at the document as we...
And Your Honor, just one observation, which is that I received their response last night. I've done my best to get through it this morning and everything like that. I think I understand most of these requests.
Okay.
You know, there may be a case where it's beyond what I was led to understand here.
Okay.
So, but with that caveat,
We'll be reasonable here. I promise you that.
Yes, so I'll just go one by one. The answer from the Circuit Attorney's Office to request number 1 was yes. Number 2 was yes. Would you like me to slow down?
Please. Okay.
Okay, so the yeses, thank you. The yeses were 1, 2, 3, 4, 10, 15, 16, 17. There were also 22, 39,
okay.
45, 47, 48, 49.
Okay.
Those were all the yeses.
Okay.
And we agreed upon some search terms and things like that in order to reach those yeses.
So we're not necessarily saying you're going to produce everything that's requested, but you all have come to an agreement and you know what you're doing with those.
Yes, Your Honor.
Yes, Your Honor. Then there are some maybes or partial, which were...
That's less promising.
So that they would look into them.
Okay.
So it was not a hard no, it was not a yes as well. And those were 50, 51, 52, 53, 56, 13, and I believe 5.
5?
Oh, and then 11 is partially a maybe. The rest is no.
11 is partial and the rest are no.
Yes, there's some no's and there's a partial maybe. The rest are no's. So I'll just, the no's are 6, 7.
Hang on one second, Counsel.
Sure.
I'm having trouble pulling this thing up, and then I left my copy back in my chamber.
Of course, thank you, Your Honor.
Write down your numbers. Sorry about that.
Sure, of course, Your Honor.
All right, no's are
6, 7, 8, 9, 12, 14, 18, 19, 20, 21, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 40, 41, 42, 43, 44, 46, 54, 55, 57, 58, and 59. So a majority of them are all no's.
okay.
We'll be happy to work with them in the future, but
Yeah, well, and that's part of the question is, do you want to argue these and make me have a ruling on them, or do you want to try
Yes.
to continue to work? Yes? Okay.
yes, we would like rulings on these. Your Honor.
Okay.
I don't think we're available right now.
Yeah, we agreed.
Oh,
No,
Glenn,
Your Honor, I just got these last night. I mean, I just got these late last night in terms of this format. I would propose that we be allowed to file a responsive pleading or reply which says what exact privileges we're invoking here, what exactly the danger is to the community from the release of this information, and that the court then proceed on that basis. And they asked if they could file a response to that, and I said that is fine.
Judge, here's my objection. They opened the pleadings by raising these blanket objections, and in doing so, they have delayed and made it difficult for the court to rule on them. And so we put in the time over the weekend to set forth what the analysis is for each of the privileges that they identified. We set forth the relevance for each of the documents that are listed in the pleading. We're ready to go. This blanket objection, and then we'll come back in 2 weeks with better objections, because what will happen, Your Honor, is the court will rule on the motion to quash, then there'll be a production, then there'll be more objections. We'd like to move forward.
Your Honor, the requests that we've agreed to are going to require a massive expenditure of the Circuit Attorney's Office's resources. These people have jobs that they have to do during the day to ensure public safety. We are meeting them more than halfway by agreeing to give them the information that we have in 13 requests from this document. That itself is going to take a little time, and we are willing to start that process right away. So we have made substantial progress here, but I do think, in fairness, we should be given the opportunity to say why some of these requests exceed what is proper.
Well, I understand your position. My concern is that, this has been set for hearing for some time. And I mean, I understand you didn't have the response until this morning, but presumably you made your, if I was to ask you, well, what's the burden on a particular request, you'd have an answer for me.
Oh, I don't even understand half of these.
And then again, so part of my concern is that you've just now today gone and talked to somebody about them. Is that fair, other than saying that you'll give a protective order at some point?
I'm sorry, talk to them?
The attorney general.
Yes, I've done that today.
The entity who could potentially clarify the scope of the requests for you was not consulted until today.
Your Honor, I didn't get their pleading until last night. I don't understand when I was supposed to be doing a lot of this, clarifying. I mean, we did have a conversation last week where we where we started the process of hammering out a protective
Yeah,
order,
that's- I mean,
which also
you-
has to be done. A protective order needs to be hammered out for all of the requests that we're going to comply to, that keeps this information confidential.
No, I
So-
mean, I agree that there's going to need to be some type of protective order put in place on this,
Yes.
and I'm sure that the state's okay with that too. And so,
That's
so
right, Judge.
part of the thing, my concern is that the type of, you know, the type of delay that will happen in a case like this one, where the people of the state, of the city, really want to know an answer, you know, sooner rather than later. And we'll talk about that a little bit later. And I'm not saying, y'all, that I'm going to rush but we're going to rush anything. But this is not something where, you know, this is something where time is of the essence.
Well, I think we can do a much better and more efficient job of submitting this on paper to Your Honor regarding our objections and what the privileges apply than doing it here in court, where I am not prepared to go through 40-some requests and list every privilege that could be applicable here, or even some of them I don't understand, and I just told them I don't understand them.
But part of my question to you is why not?
Why don't I understand? Because of the way they've written.
Why are you not prepared?
Because of the way they've written them. You know, is that my fault? And also, I just got their pleading last night, stating what the basis for the allegations were. I was only able to read it this morning on a plane.
No,
Judge.
If I could be heard just for a moment, Judge.
Sure.
And I just want to be clear about two things. One, they've had our subpoena for a lot longer. Our pleading is in a response to their blanket objection as to privileges, which they didn't identify any privileges as it relates to any particular request, and relevance. And I went far and beyond what you might do in a normal civil case and identified which particular paragraphs in the amended petition relate to each request. Additionally, with respect to the privilege law, protective order, we did have a conversation about that last week, and my recollection from opposing counsel is they hadn't thought through that yet. Which, again, to your point, you know, we need to get a decision on this case, as you said, one way or the other. Just this week, we had people fail to appear for a jury trial. This case needs to be moved.
Yeah, Your Honor, we agree, and we're willing to move with dispatch, but that being said, you know, the whole purpose of a motion to dismiss is not to impose the burden on the parties until the court has resolved the motion to dismiss. So I think that is, you know, black letter law on one of the reasons for the rule on motion to dismiss. So I think, you know, our request for a little bit more time, now that the court's asked us to assume certain things about the court's ruling, is not improper.
How much time are you looking for?
You know, Your Honor, we could get something to the court within a week on our objections.
Here's what I want to do. I want to talk about some of these generally, and then I will give you a week to file a response.
Okay.
Okay? Have you on the ones that are yeses and the things that are maybes, have you all already agreed on a time for production of those?
We have not, Judge. I raised that issue, and I think we're going to need some court guidance on the time frame.
Okay.
This is an enormous amount of information.
No, I'm with you. I understand. So what my question for you all is, I want to get this subpoena resolved as we possibly can today, so that everybody has some guidance on the way going forward. And to the extent that, you know, any rulings I make on a motion to dismiss will make things no longer relevant, I can include that in an order going forward. You know, we can whittle it down as we go to the extent that that is something that happens. Okay. But what I need to know right now is, what do you need from me to get this as resolved as possible? Because you've got a pending motion to, you know, for a protective order, and you're telling me that you're not completely ready to talk about all of the issues.
No, I'm ready to talk about what's in our motion and the privileges we cite, and the fact that many of these requests are oppressive and burdensome. If we want to go through and do that today, it's going to take a long time. These requests are very wordy. Some of them are very hard to understand. But you know, if Your Honor wants to do that, I again think the best way to do this is on paper. But if we want to start that process today, we can see how some of these requests read and whether we even understand what they mean. You know, and some of the objections. But I do think we should be given the opportunity to file something, as Your Honor just noted.
Okay. And the state would like to argue these today. Is that
yes,
right?
Judge. They filed 4 pleadings about this subpoena. They've had 4 opportunities to say, we don't understand what this request means. They have not done that. We're ready to proceed.
Okay. Well, I'll hear from the state, and if you'd like to respond, then we'll do that. But you can also, I will give you 1 week to file a written response to their pleading and anything that's said in court here today. And then you can also stand up and make an argument if you'd like.
Okay.
Thank you, Your Honor. I would propose that we just move through in chronological order or numerical order. So request number 6, documents reflecting the Circuit Attorney's compensation, salary, and benefits, as well as her timesheets. Your Honor, there's an allegation in the answer and affirmative defense that we haven't alleged that she's responsible or that she's aware. Those items, especially the timesheets, are directly relevant to how she's spending her time in office and whether or not she has notice and ability to be aware of these things. I think that that's eminently reasonable for us to ask for.
Mr. Jeffers, I understand I just told you you could argue later, but I'm curious as to whether the circuit attorney has timesheets at all, if you know.
No, that's something we told we need to look into.
You would need to look into on that. So 6 is one of our maybes, or no? I got it as a no.
Hey, Judge, I can't answer that. I want Bob Plunkett for the tie over to it.
Yes.
You had a question, my client's an ACA, was an ACA. There are timesheets.
Okay. Thank you. No, thank you, Mr. Plunkett.
Number 6 is documents reflecting her compensation, including her salary and benefits.
Oh, I'm sorry.
Number 7 is timesheets.
Number 7 is timesheets. I apologize. Okay. So what is that relevant to? Just showing when she was there?
Yes, Your Honor. She's required to devote her full time to the office in statute, and so if her allegation is that she's not personally involved in any of these acts, I think it's relevant for us to look into whether or not she was at the office.
Do you have any response to that at all?
I'm sorry, Your Honor, I couldn't, I think they were merging 6 and 7. I mean, 6 is asking for her salary and benefits, including her gasoline and parking. I think that's completely irrelevant. I don't think there's any need for that. I don't see how that relates to any of the allegations in the petition.
Yeah, I'm having a hard time with that one too, counsel.
Yes, Your Honor. So in their motion to dismiss, they've argued that the nature of this action is to the title of the office, and along with the title to the office come the compensation scheme. And so if they're saying that this is about the title to the office, well, we ought to be able to investigate what is attached to that title.
You don't have any allegations that she's somehow stolen money or anything that these records would help you demonstrate?
No, Your Honor.
Okay. How does this show title to the office, other than that she gets paid money, which we all probably can stipulate to?
Yes, Your Honor, that's it, exactly.
Okay. I'm going to quash that one. I'll put an order together on all this. That's number 6.
Yes, Your Honor.
Number 7, is there a way, if there's a timesheet, is there a way that can be redacted so that it shows when she was in the office?
I'm not confident this, just because an ACA has timesheets, that means Ms. Gardner does, but we will look into that and,
Okay.
and then see if there's some form we can produce that in, perhaps redacted, Your Honor.
Okay, thank you. So I got number 8 is the next one I have a no on.
Yes, Your Honor, that's her evaluations from her personnel file when she's an assistant circuit attorney. That's sort of connected to number 9, the cases that she was involved in, both as an assistant circuit attorney and while she's a circuit attorney. Here's why those are relevant, Your Honor. The allegations in the petition are towards a failure to manage the office. She was a previous employee of the office. And so her understanding and knowledge of the workings as a line-level employee are incredibly relevant to how she manages the office as a supervisor. And I think there's probably going to be some discoverable information in there that would lead to relevant admissible evidence at trial.
This is completely irrelevant. Personnel evaluations from when she was not even in her current position. First of all, personnel evaluations are highly confidential documents which are done, for the purpose of evaluating an employee. They're never meant to be given to a third party. But relevance also, Your Honor, these have nothing to do with the allegations of the petition. This is a pure fishing expedition.
I disagree, Your Honor. Her argument has essentially been that the line attorneys are the ones engaging in the failure. What she knows or doesn't know about how the office operates is incredibly relevant, And the fact that she worked there previously is relevant to that scope of knowledge. Any of the concerns about confidentiality can be cured very easily with a protective order, Your Honor.
All right, I'm going to take those under submission.
Judge, if I may, the statement's been made several times. I think we need to correct something. Ms. Gardner has actually denied any wrongdoing by anyone in the office effectively. There are allegations there were mistakes made by the assistants. Ms. Gardner is not blaming them for anything. She's only saying, I deny the allegations against them, but beyond that, even if they did something wrong, as you allege, it cannot be a grounds for Ms. Gardner to be removed. That's different than blaming her for everything. And I ask that you request the Attorney General restrain herself from saying she's trying to pass the buck and blame her subordinates and thus not showing leadership of this office.
Understood.
This obviously is very public and it's a very harmful allegation, not only against Ms. Gardner, but against the other people in the office.
Understood. And I will note that the Attorney General, or not the Attorney General, but the Circuit Attorney has denied all wrongdoing. And let's just keep that in mind as we proceed.
Sure, Your Honor. And just to be clear, Your Honor, I'm talking about paragraph number 12 of their affirmative defenses. So
No,
anybody can look it up and be clear about what I'm talking about. That's what I mean.
Understood.
Your Honor, one more objection on 8, and I think this is also going to apply to 9, which is that this is not about Ms. Gardner's personal capacity, about her past employment, her past evaluations and everything about it. This is her in her official capacity. Many of these requests, both 8 and 9, pertain strictly to her previous employment. They don't even have to do with her in her official capacities, which is what she's being sued in. So it's irrelevant for that reason as well.
Okay. Thank you. Any further response on that one?
Just if we're moving on to number 9, Your Honor, her knowledge about how...
Well, let's read it. Let's read it. Any list or summary of all felony and misdemeanor cases that Kimberly Gardner tried when she was an assistant circuit attorney and as the circuit attorney.
So I'm not hearing any objection to the last half of that request as to cases that she's been assigned or tried as a circuit attorney. As it relates to any objection to the cases she was assigned or tried as an assistant circuit attorney, Your Honor, that goes directly to her knowledge about caseloads, which you heard about earlier, as well as how the office worked when she was a line attorney. I think that's directly relevant to her knowledge as the circuit attorney.
Is there any objection to listing the cases that she tried as the circuit attorney as opposed to an assistant circuit attorney?
I don't think so in principle, Your Honor. I'd have to confer with my client about that, but we will look into that.
Okay.
But not the first part.
Okay. All right, let's go to 12. I'm going to take that under submission. I'll go to 12. No. Yes. 12 is one that's a no, correct?
Number 12 is the next one on my list, Your Honor. Yes. That relates to draft and approved budgets for the fiscal years while the circuit attorney has been in office. Your Honor, her ability to staff and maintain the office, including requests that she made to the city in terms of how many employees she needed, at what level they needed to be there, that's all directly relevant to her personal knowledge about how the office is run. Her office, and ultimately she personally, I suppose, is responsible for those requests. I think it's eminently reasonable for us to get those.
Yeah, first of all, not draft budgets. I don't see what the relevance could possibly be of draft budgets, and they have not articulated any here. As to approved budgets, I believe those are already publicly available, and they could get them. As if they want an approved budget, that's something we can look into. I'd have to see if there's what kind of sensitive information there is there that might have to be redacted or something like that, but that is something we could look into.
What's the relevance of the draft budget as opposed to the approved budget?
Absolutely, Your Honor. So the draft budget that the Circuit Attorney's Office submits is not just give me $10,000 for salaries, for instance. It is give me this many attorney ones, give me this many attorney twos, this many attorney supervisors in these sections. So it's broken down not only among attorneys that might handle violent crime, but also among attorneys that might handle sex offenses. It includes how many investigators, how many victim advocates. Those all directly relate to the allegations that the office is not fully staffed. And if she's asked for 15 employees, but really needs 20, that's directly relevant. And if she's asked for 15 and has gotten 15, but can only fill 5, that's also relevant to her knowledge. So that's the relevance of the draft budgets, Judge.
wasn't responsive to Your Honor's question. I don't think that's an answer as to why they're relevant. But like I said, we agree that they are underfunded. It's an underfunded office. It's a bunch of people trying to do their best with less resources than what they need. We absolutely agree with the Attorney General's office on that point. But I'm not sure how it's relevant to the petition, frankly, and this just seems beyond the scope.
Would draft budgets be something that are available under sunshine law request?
Your Honor, I'm not an expert in sunshine law. I'd have to think about that. My guess would
Well,
be...
and I'm not suggesting that I'm going to make you do a sunshine
No,
law
I'm-
request to get it. I'm just suggesting that if it would be available versus the sunshine law, on the sunshine law, then it needs to be turned over in this case too.
I can't think of any of the particular exceptions under the sunshine law. And of course, as the court knows, the general rule is, unless there's an exception, the record is open. So my guess, and it would be a guess, is that it would be an open document.
What, for the drafts, Your Honor?
Yes, sir.
I don't know if they want to go through the sunshine law. I think that's their recourse here. Having these people pull together something that's completely irrelevant, doesn't go to any of the issues raised in the petition. That just seems burdensome, oppressive, a waste of taxpayer resources.
And these budgets are relevant to all of your counts, or are they tailored to a particular count?
To all the counts, Your Honor, that involve the staffing of the office. And again, just so that we're all very clear here, the draft budget submitted by the Circuit Attorney's Office would say, I would like to have 15 Attorney 1s. That's an attorney that handles a line level case. It might say, I want to have 10 Attorney 2s. That's somebody with a little more experience, 5 Attorney 3s. Her requests to the city for money as it relates to a specific number of positions, which she lists in the draft budget, is directly relevant to her knowledge about how the office is staffed, and that is pled throughout the complaint.
All right, I'll take that under submission. 14.
Your Honor,
Yeah, we didn't agree to 12.
I'm sorry, Your Honor, number 12, I think.
Oh, sorry, number 12. I skipped over 12.
And number 12 is communications.
Let's read it. All emails and text messages discussing the CAO's draft and approved budgets for fiscal years 2017, 2018, 2019, 2020, 2021, 2022, 2023, and 2024, including the process for drafting and approving the CAO's budgets.
Yes, I'm not hiding from the fact that we want Circuit Attorney Gardner's commentary on her budget requests.
How is that relevant, Your Honor? I don't see how that's relevant. And also, the request is for all emails and text messages. This is a textbook example of a fishing expedition, of something that's absurdly oppressive and burdensome for an office of public servants who have another job to do, to be pulling this together. This is not possible to be done anytime within, and even if we wanted to, this is not possible to be done anytime within the time frame that we have here.
Is there anything you can do to limit the scope of that request?
Your Honor, I'd be happy to limit it to the people that they want to identify as having participated in the budget process. But I don't know who those people are. I would think that it would be trivial to run a computer search in the emails for budget and get the results, but perhaps not for the Circuit Attorney's Office.
All right, I'll take 12 under submission. 14.
Your Honor, number 14 relates to warrant applications. That's directly related to a claim pled in a petition. Specifically, we're looking for the number of warrant applications submitted by month to the Circuit Attorney's Office. Number 14, sir.
Yeah, I got you.
You got it? Yeah. Okay. We're looking for the number of warrant applications submitted by month to the Circuit Attorney's Office, including the number of warrant applications where charges were issued, refused, and taken under advisement, including the dates that they were assigned for review and the date they were actually reviewed. That relates directly to one of our claims pled in the petition.
What's the objection to that one?
Your Honor, this gets into the circuit office attorney's decision-making, which is protected by the deliberative process privilege. This is also, I don't really
Isn't
quite...
this just a request for the number, or some documents showing the number of warrant applications?
That's correct.
I mean, Your Honor, this doesn't relate to any specific case or instance of, I guess, negligent operation of the office, which is all that the amended petition alleges. It's just, it's irrelevant, it's sensitive, it's protected by even the number, I think. They're not entitled to go into every aspect of the decision-making of the office. Also, I don't know if this information is available. This is not something that would be kept in the regular course of business. And if it isn't, there's nothing to produce. I guess we could just tell them that. But that is another reason to object.
Okay.
Your Honor, if I could respond. Sure. As I pointed out in our response, no Missouri court has ever recognized the deliberative process privilege in Missouri law. There is exactly one case on the topic. It's from the Western District. I think it's from 1990. And it analyzes the deliberative process privilege in the context of what it is, which is an exemption from the Federal Freedom of Information Act. So allegations that somehow the number of warrant applications that came in are protected by that, I think is misplaced.
It doesn't just have to be framed in those terms. I think deliberative process privilege does cover this, but it could also be said that this is just very sensitive information, and they're trying to pry into the inner workings of the office in a way that should not be allowed, Your Honor. No office should be allowed, no government office should be allowed, or agency should be allowed to be picked apart like this. I mean, this is not directly relevant to any of their claims, contrary to what the government just said.
But it is, Your Honor. We pled that they don't review warrant applications on time.
Thank you, counsel. I'll take that one under submission. Argument on 18 is the next one I have. Is that right?
Yes, Your Honor. Number 18 concerns, and I can list them specifically if the court wants, but emails and correspondence between Chris Hinckley, the circuit attorney, Serena Wilson Griffin, the first assistant, Marvin Tier, the former chief trial attorney, Reddit Hudson, who's in charge of the diversion program, Maurice Foxworth, who, upon information and belief, is a high-ranking member of the administration, and Eula Simmons, who is the executive secretary, regarding staff shortages and turnover, which is pled in our petition, warrant application backlogs, which is pled in our petition.
Yeah, and I understand the relevance of these. I'm curious as to what the objection is.
Oh, thank you, Your Honor.
Well, Your Honor, I mean, let's keep going. I mean, C says victim information in any case identified by cause number in the amended petition, complaints or concerns expressed by assistant circuit attorneys concerning the number of cases assigned to them, and our complaints or concerns regarding training of assistant circuit attorneys. Judge, the office should be allowed to discuss these matters internally without the expectation that that information is all going to be given to anyone that comes along with a subpoena. It's not appropriate to invade the deliberations and the internal workings of an agency this way. It's also not particularly relevant to this. I mean, they might have complained, oh yeah, we don't have enough staff here. So what?
If there's numbers of, numerous emails complaining about this issue, wouldn't that help the state to demonstrate that, the circuit attorney was aware of these issues and yet took no action? Or at least at the very, maybe not the second part of that, but at least that she was aware of these issues.
Your Honor, first of all, they're asking for any and all emails or correspondence. That is a massive undertaking. That would be extremely expensive, involve thousands of man hours in order to retrieve that kind of information, to even search for this stuff. Also, I used to be a public defender. All we did was complain about staff shortages and turnover. You're talking about a potentially massive amount of information. They just should not have to do this.
They
can take depositions, Your Honor, where they can ask them, if the court denies the amended petition and, it's relevant, then potentially they could take depositions where they can ask people about this. That's the recourse for this, not some very expensive search at taxpayer expense.
Understood. And so, is there in your response, Mr. Jeffress, I'd like you to give me some idea of what the types of expenses are that you're claiming. So if your suggestion is that something is unduly burdensome, that something is going to cost a lot of money, I want to have an idea of what that looks like, so that we're not just working in kind of a void of information here, which is where I kind of feel like I am right now.
Yes, Your Honor, I agree. That we will do that.
Okay. So one, I'd like that, and two, would the state be willing to limit the time frame on 18 to something that doesn't encompass the beginning of time?
Sure, Judge. And to be clear, it's not any and all emails and correspondence always and forever. It's to or from these particular people. So,
right. And regarding particular topics.
Exactly right, Your Honor. So the email search is going to be limited by the amount of time these folks have worked there. Right? Okay. But we weren't even able to make it to a discussion about time or search terms or any of those kind of discussions that you might have because the response was no, we just shouldn't get any of it.
Well, let's assume that I'm going to give them some of these things. This should be one of the points of your continued conversation
That's
after
fine,
we
Your
get
Honor.
out of this courtroom.
And in particular, Your Honor, I just want to repeat what they're asking for.
And actually, that's a good point, and it just reminds me about a question I have is, I understand that part of the allegations here are that the circuit attorney has not been informing witnesses as to what's going on with their cases, but I do have some concern about, all communications about victims or to and from victims in cases and what that might look like. Is there a way, what in particular are you looking for when you're talking about communications with witnesses or about witnesses that we can maybe hone in on and give them a little bit more guidance so that we're not, having every witness who ever poured their heart out to a circuit attorney having their emails made part of this discovery?
Sure, and I understand the court's concern. Let me start by saying we're only looking at victim information in this sub-piece, not all witnesses.
Yeah.
So that's
And I apologize if I used the word witness. I meant victim. So
I understand, Your Honor. Just a couple things to think about. One, kind of the overarching thing, what we're looking for here is complaints or discussions about efforts to contact victims. So in other words, if, for instance, there was an email between the first assistant and the circuit attorney saying, we haven't contacted this victim, we need to do that, and then they're never contacted again, well, that'd be a great piece of very probative evidence for our case. That's the kind of thing that we're looking for. And the other second piece I want to just make sure that we're clear about here is statements from victims that are made to the circuit attorney's office should be produced in discovery to the defense in the individual criminal cases, assuming that they're that they're relevant. There's an obligation to disclose those. So I would think that there is some effort already made underway by the circuit attorney's office to make sure that that's been collected and done.
No, that's not what this is asking for. This is asking for any emails between all of these people about victims in any case identified by cause number in the amended petition. So, their ascertainment as to a victim's credibility, as to various issues the victim might have. Your Honor, victims are not going to report crimes if they think that their information is going to be sprayed all over, the press by the Attorney General's office. Like, this is extremely unfair. This is extremely improper request.
I don't know what evidence there is that we have ever or would ever do that sort of thing. So we can lay that one to bed right now, Judge. But as we've said before, and as I said in the response, I'm happy to agree to a protective order. And if there's, even beyond the protective order, if there's information that the circuit attorney's office feels in sub C is so sensitive that a protective order can't handle it, of course, they could always ask the court to review that in camera.
And I think that some of this is going to have to be handled by either you all producing some type of privilege log, or even if it's a log of concerns, and then I'll have to take those up more individually, and we won't, obviously, I'll just do that. But, so I think that that's the way that some of that's going to have to go.
Okay.
I think that as we've been sitting here going through these, what I'm thinking I'm going to end up doing is I'm going to take everything that we've talked about, all of these points under submission today. I'm going to issue one ruling that is going to come along on the heels of any ruling on motion to dismiss. So we'll get all of these rulings, everything out at the same time, and of course it'll come after you've had an opportunity to respond.
That sounds.
And so I'd like to continue to kind of go through these and just kind of get a sense of what the big relevance and what the big objection is, and then we'll move forward. But I think that we should continue to go forward with the idea that a protective order and a privilege log is going to be, my recommendation on things where we have that type of concerns, because I too share concerns about, some information from victims and things that just doesn't have any real relevance to this case being out, Though I also do not believe that the Attorney General's office is going to be splashing any of these things.
But just the mere fact, Your Honor, when this is reported on, and when victims out there find out that their information is being traded between agencies and is the subject of this hearing and everything else, I think anyone can see that right there is a threat to public safety. That's not fair to these victims who are already victims of a crime. That's just not right. And they shouldn't be asking for this information, and they shouldn't be using these people as pawns on a chessboard, which is exactly what they're doing. You know, on the victim stuff, and we're about to get into a lot more of it. You know, it's just improper, and I think the court should categorically exclude this information and witness information and confidential informant information from any of our discovery.
And the basis for that is just the fear that the chilling effect that it might have on future
That's a big part
victims.
Of it. That's a big part of it, and I think also just fundamental fairness to these people.
Okay. And I'm sensitive to that, and my curiosity is whether we can find a place where, you know, we can limit some of these things to where we're, you know, not necessarily getting into that type of concern. But so I will take 18 under submission. Let's just talk about 19.
19, Your Honor, is complaints essentially sent to or received from any assistant circuit attorneys regarding the number of cases assigned to them, concerns about training, concerns about staff shortage or turnover. Again, Your Honor, if there's emails documenting the line folks saying we're underwater and we need help, that's relevant, discoverable, it's great evidence.
Is there anything more than a relevance objection to this one?
Yes, you know, searching all emails sent to or received from any assistant circuit attorney is just not workable, Your Honor. And we will, you know, every time they ask for something like that, you know, we object, because that is, I think it is beyond the pale to require public servants who are doing their real jobs during the day to have to go through all of this information, assemble all of this information about all emails sent to or received. There's not personnel established in this request. There's no time frame established in this request. It's just general complaints about their jobs. This would take a year for us to produce this kind of information. I'm not going to say we have in good faith complied with this request. It's just not possible.
Well, is this something that we can limit through agreeing to certain search terms or certain use of an e-discovery service or something like that?
Absolutely, Judge. We'd be happy to have that conversation, but we were met with a no, you can't have anything.
Okay.
So,
let's put this on the list of things you ought to talk about before I issue a ruling. So it's hard for me to say that's blanket, you know, irrelevant, and it's completely oppressive if there are ways that we can make it such that it makes sense to do, because obviously, based on the scope of their petition, I think that there's things that will be relevant in there.
I think it's far too broad as it is, Your Honor. But
No, I don't necessarily disagree with you, but I think that let's see if you all can agree on a way to limit it without I don't have to do it.
very good. Thank you, Judge. Next on my list is number 20.
Yes.
It's a caseload report for all current assistant circuit attorneys, including supervisors. Your Honor, on information and belief, the circuit attorney's office utilizes a program named Carpel or PBK. You can punch into that to give it a list of the cases currently assigned to each employee in the office.
Yeah, I just don't think we should have to produce something like this. Again, they're prying into the way the office works on a day-to-day basis. No government agency should be exposed. And there's no precedent that they've cited for any government agency, such as the Office of Circuit Attorney, ever to be micromanaged or to ask for this kind of detail. This goes beyond anything that I've ever seen. They should not be allowed to pry into the inner workings of the office in this way, and then, you know, potentially use that information in all sorts of ways that could become public. It's not proper.
Part of my concern with that argument is that this entire lawsuit is about the inner workings of the office.
Which is why it should be dismissed, Your Honor.
Fair enough.
Yeah. One reason.
All right, I'll take that under submission. Let's do 21.
Yes, Judge. It's my understanding that currently, or at least at some time in the recent past, the Circuit Attorney's Office has issued employee surveys to its staff. If those exist, and I think that they do, I think that if the Circuit Attorney's Office as an entity is soliciting information like that from its employees, it's presumably looking at those. I think it's fair to think that the Circuit Attorney would have some interest in the results, and so I think we ought to be able to discover those.
Would employee survey by the circuit attorney be detrimental to your case if it shows that she's actually reaching out to her employees to figure out how they're doing?
I think it certainly would be, Your Honor. These are done with the expectation of confidentiality. And if the court just, throws that out the window, that's not fair to the employees who filled out these surveys. That's not fair to the office. We can't go back and just say, hey, everything they told you about how, these would be, your opinions on these things would be kept within the office. They were just for our review, and then the court comes in and overturns all that. That Your Honor, that is highly objectionable. And also, I don't understand how it's particularly relevant. So somebody might say, I wish we had more of this, or I wish we had more of that, or I wish we didn't do this or do that. It's not directly relevant to any issue in their complaint. Maybe it goes to morale, but low morale is not a basis for a quo warranto petition. This is not. Employee surveys, that's just not fair to the employees there. It's not fair, and it's not fair to the management either.
3 responses to that, Your Honor. First, the Attorney General's aim in this case is to do what's right. And so if that involves uncovering evidence that helps the Circuit Attorney's Office, that's what we're here to do. But I suspect that the evidence that we're going to uncover is going to be helpful to our case. We specifically pled that the Circuit Attorney has created a toxic work environment. And so employee surveys about the work environment are directly relevant to the claim pled in the petition. If they have concerns about how that could be used or what we might do with it, of course, that's fodder for a protective order.
I would challenge the Attorney General's office to come up with a single case where a court has permitted this kind of intrusion into an office's operations, where they're looking at employee surveys that are done under a promise of confidentiality, and they're saying, yeah, you can look at those, you can just fish through them for all the kind of complaints you want. It's just not right, Your Honor.
Yeah, and there's this. I do have some concerns about some of these things with respect to that Delmar Gardens case, saying that personnel files are to be confidential. So some things like this, where you're getting actual responses from individual employees.
And Your Honor, I haven't seen any of the employee surveys. Of course, Mr. Jeffers is representing that it's going to be individual responses. I kind of suspect, however, that employee surveys are usually done in an anonymous fashion with bulk data. And so, Mr. Jeffers and his client have access to these. I don't, so I don't know what format they're in, but I suspect, Your Honor, that, again, a protective order can take care of any concerns that the Circuit Attorney's Office has.
The objector.
Have you seen any of these surveys? Do you know what they look like?
No, Your Honor. I can look into it.
Okay. What I'd like for you to do then is to take a look at them and have some kind of let me know in your response whether this is something that can be redacted, whether it's a generalized survey, whether if you can to redact employee names out of the top of it, then it might be something that we can have turned over. My concern is that there's I don't want to jeopardize any employment related confidentiality that these employees might be entitled to.
Absolutely, Judge. And again, I am remiss for not mentioning this in my earlier statement, but of course, there's an option for an in-camera review. So if redaction's not enough, the court can review that. Again, I don't think I'm looking to find information that says Attorney A has complaints about the water cooler.
Okay.
We all know what we're here for and what we're looking for.
Right. Well, once you receive this response, hopefully we'll have a better idea of what it is that what we're looking at and whether it's truly objectionable.
Number 23 is the next.
And let me ask you real quick on 21. You're asking for the results of a survey. Would that include if a circuit attorney had filled out an individual survey? Is that what you're looking for too, or are you looking for like kind of a analyzed version? This is the result that we are believing we see from or both or everything.
Right now, Your Honor, I don't know what form they're in. So
okay.
What I didn't want to be in a position of is asking for the analyzed version and then be told, oh, we only have the bulk version, and you didn't ask for that.
Okay. Appreciate it. All right, let's do number 23.
Yes, Your Honor. This relates to a request for documents reflecting the Circuit Attorney's Office's agreements, contracts, and invoices with a list of outside law firms that are specifically pled in the petition and that are the subject of a current lawsuit.
Yeah, let's just do this one via your written response. We'll
Thank
do
you,
that
I appreciate it.
on the briefs. 24 looks like a big one.
I'm sorry, Your Honor.
24, is that the next one?
Yes, yes.
Okay.
Yes, okay. With respect to all of the cases identified by the cause number in the amended petition for writ of quo warranto, please provide the following. A, all police reports provided to the Circuit Attorney's Office. B, all warrant application documents, including any communications with the SLMPD and all internal communications concerning the application. C, all internal communications concerning staffing. D, all communications with any witnesses. E, all communications with any victim. F, all internal communications, including any memoranda regarding any sanction, including any potential sanction or dismissal, whether by the CAO or by the Circuit Court. This is exactly what we're talking about, Your Honor. This is extremely sensitive information. The production of it, even the reporting that it has been ordered by the court to be produced by the Attorney General's office of this information would affirmatively undermine public safety. There are a million reasons. This 24 needs to be quashed in its entirety. It's not fair to the victims. It's not fair to the witnesses. It jeopardizes their safety. Your Honor, this is the epitome of many of the most important objections that we're asserting here today.
The Circuit Attorney's Office has an obligation under Rule 25, as well as the United States Constitution, to disclose statements made by the witnesses and the victims. So I would suspect and certainly hope that in any of these filed cases, those things would have already been produced to the defense.
That's different from producing it from these victims and these witnesses knowing that it's being produced to the Attorney General's office as part of a highly politicized lawsuit. That's completely different. Okay. That's fundamental constitutional discovery obligations that they have to produce these things pursuant to protective orders to defense attorneys in some cases. Not always. He's speaking way too broadly.
I mean, I think that if there's a protective order in this case, I don't see any problem with having her produce anything that she would have had to produce to, and by her, I mean the Circuit Attorney's Office in this case, produce anything she would have had to produce to defense counsel.
So, okay, yeah, we're going to strongly object to that. I think what the Sixth Amendment requires and what due process requires is fundamentally different from discovery in this civil lawsuit, where they're just asking for these things for the use in a quo warranto suit. Those are completely different standards. And just because they had to produce it to the lawyer for a victim, oftentimes probably on an attorney's eyes only basis, or I mean, to a defendant, I'm sorry. Oftentimes on an attorney's eyes only basis, I mean, I'd have to look into that. But there are a lot of these nuances in productions to defense lawyers. And some of this material probably was never produced to defense lawyers at all for good reasons. There may have been exceptions. So, or relevancy issues, or privilege issues, or all kinds of things. This is a highly objectionable and complicated request, Your Honor. It would be very difficult to safely maneuver through all this information for its production to them. It would take a very long time. So we object to production, to any production under Request 24.
Judge, I understand that Mr. Jeffers is not local counsel.
I understand the Jenks Act, if that's what he's going to do.
It's not. We have a more expansive version of discovery than the Jenks Act. I'd be happy to show you, but Rule 2503A requires production of arrest reports, incident reports, investigative reports, written or recorded statements, regardless of who they make.
That's different from Rule 16, Your Honor, but there are all sorts of...
Well, the point is, sir, that you're required to disclose those. There's no, you don't have to give over a witness's statement exception in Missouri. And if the Circuit Attorney's Office believes that, we may have a new count in the petition.
What I'm objecting to is the court's statement that just because it was produced possibly to a defense lawyer means it should be produced in this suit. I disagree with that. I think that's incorrect, respectfully, Your Honor. I think that's incorrect legally.
Okay. What about the internal communications regarding staffing, those sorts of things? I mean, I understand why you want that. Is there some work product objection to that?
I'm sorry, which part, Your Honor?
So
F?
24
C.
C and F, really? Any of these requests regarding, internal communications among circuit attorneys?
Again, Your Honor, I don't think...
Regarding particular cases.
I think this is an unprecedented intrusion into the workings of this office. The office should be allowed to communicate, both the supervisors of the office and the assistant attorney should be allowed to communicate without thinking that their communications are someday going to be revealed to the Attorney General's office for use in a lawsuit like this. It's not right. There should be a expectation of confidentiality, an expectation that their words are not going to be used in future litigation. And this will inhibit communication between prosecutors about their cases if they think that this is what will happen someday. This is a very real danger in this case. And I would challenge the Attorney General's office to come up with a single case, one time, where an Attorney General's office or anyone has been allowed to probe into the inner workings of an agency in this way. I seriously doubt it exists. It's unprecedented.
On that one, in your response, I'd like for you to let me know what kind of work, what kind, what's the burden, et cetera, that it would take for you to have to produce those sorts of things, and to what extent you believe it would contain, privileged information, and whether that can be addressed by a privilege log.
Yes, sir.
That would actually generally be good advice on responding to every one of these things.
Yes, sir.
25.
I'm sorry, Your Honor. I know the court wants to move on. If I could just be heard very briefly on 24.
Briefly.
My only additional point, and this applies to some of the other things, Your Honor, is that what we have here is the Circuit Attorney's Office and the Circuit Attorney with different attorneys playing both ends against the middle. The Circuit Attorney, on one hand, alleges she has no knowledge of any of these staffing problems. And then the Circuit Attorney's Office as a legal entity comes to court and say, well, we couldn't possibly produce any of the documentation that would show that she has knowledge. I just want to make that observation, Your Honor.
Understood.
I think you know that's not a fair observation of Ms. Gardner's position. I ask again that the Attorney General be asked to restrict himself to truthful statements about what Ms. Gardner said.
Thank you, counsel. All right, where are we?
Number 25, Your Honor.
25, Vera Institute. Why is Vera Institute relevant?
So, Your Honor, we pled in our petition some allegations relating to the Circuit Attorney's use of the Vera Institute, communications with them about how she would discharge her duties. I think that makes it very relevant. In addition, it's my understanding that the Circuit Attorney wrote a foreword for a booklet or a pamphlet for the Vera Institute. We pled that she made those statements in our petition, and those claims were denied by the Circuit Attorney. And so we have a situation here where there's some paperwork that says the Circuit Attorney says this. The Circuit Attorney has denied saying it. I think we're entitled to discover what's true.
No. Your Honor, as Your Honor observed, this is just irrelevant to the claims of the petition. I mean, so what? Let's assume that some documents, some emails exist where they are, corresponding with the Vera Institute about various public policy issues and views and so forth. So what? How is that possibly relevant to any of their cited instances of prosecutorial negligence, which is really all they ever do, in the amended petition? It just, they don't go together. This is something that, and once again, I think, we're getting into an area where we're trying to intimidate, public officials who want to explore different ideas about how to run the office, be innovative perhaps about how to run the office, reflect the views of the voters of St. Louis about how to run the office. And we're doing that in a way that's going to prevent, subjecting them to civil discovery in this. I doubt there's, again, any precedent for this. And we're doing it in a way that's just going to intimidate people from ever doing anything like that. It's not right. They should be allowed to explore ideas and everything like that without it being the subject of a lawsuit. And I think Your Honor knows this is a highly political request. It was a highly political interjection into the amended petition.
So, Your Honor, we pled at paragraph 237 that the Circuit Attorney's Office followed the Vera Institute's recommendation on dismissing cases, and if she communicated with them to get that recommendation, I don't know how else she would have. We're entitled to discover that.
Okay.
And Judge, just that allegation was denied.
Thanks, sir. I assume that almost all of the allegations were denied.
That allegation was directly denied.
Okay. Thank you. All right, let's do 27.
I'm sorry, Your Honor. I think you skipped 26.
No, I think we...
Did I?
Yes, that relates to non-disclosure agreements or non-disparagement agreements.
Thank you. Thank you for keeping me honest.
Just trying to be thorough, Your Honor.
Yeah.
The Attorney General's Office has attempted to meet with potential witnesses, as the court might expect, and some of those potential witnesses have indicated that they cannot give information to the Attorney General's office because of non-disclosure or non-disparagement agreements. The signing of those in a public office would be highly unusual in my experience, and I think we're entitled to get some discovery into this.
Is this a Delmar Gardens issue? Are you familiar? You're familiar with the case?
I'm familiar with that case in that it sets forth the standard, I believe, for a writ of prohibition. I'm not an employment attorney, so I'm not as familiar with the exact metes and bounds.
Yeah. Oh, and I'll have to apologize if I'm citing the wrong case, but I know there is a case out there that makes personnel files effectively confidential unless there's something put at issue directly, and so kind of some of my concern with this one is that we might be getting into an area where if this is something that's part of somebody's employment and their personnel file, that are we pushing our limits there?
And Your Honor, I'm certainly sensitive to those concerns. I will tell the court that my belief is that Delmar Gardens is a case involving a writ of prohibition on that employment topic.
Wonderful.
I don't know the case chapter and verse, so I don't want to represent that I do. This is an area, and I understand sort of the court's approach seems to be, is this in a sphere of things that is more confidential or more privileged or has heightened concerns? And I think that the appropriate response to that would be that would be a great area for production to the court for an in-camera review.
Your Honor, on this one, can we? I want to review what Your Honor just said. Can we submit this one on the paper, and I can elaborate on our objection there?
Yeah, that's not a problem for me. And I'd like for you to look into whether, one, these things exist, and two, to the extent that they do, is there a way that they can be redacted that would at least show the Attorney General's office the extent of these types of things, whether it's with specific employees or not?
Thank you, Your Honor.
Would that be acceptable to the Attorney
Absolutely,
General's office?
Your Honor, if I may, just for a second, we're not looking for employment files here. We're looking for alleged non-disparagement, non-disclosure agreements that are post-employment restricted covenants. We reached out to a counsel who said that their word is one of their former client or former employees want to speak to us because of an alleged non-disparagement or non-disclosure agreement. That's what we're looking for.
Okay.
Whether that's enforceable is a different story, but to me that's discoverable as to any employment with respect to post-employment. It's not part of the personnel file.
Okay. Okay. And so if we limit that to
Yes.
That's the problem, is that you have, employment agreements, confidentiality agreement. It's just the way that it's worded is relatively, broad.
I
And
understand.
so if we can limit that to, I'm curious as to whether there's a way to get you information that you'd like, without running afoul of any kind of, confidentiality concerns that employees might have.
Right, Your Honor, and Mr. Corrigan is exactly right. We're looking at post-employment, non-disparagement, and severance agreements. Certainly nothing as it would relate to a current employee.
Okay. And that would that include, if there are employment agreements that have a restrictive covenant in there at the time, of hire, are you looking for those as well?
No, Your Honor, just only agreements that were entered into after or shortly before. So in other words, if the employee signs it on their last day, I would categorize that as a severance agreement. I suppose that would technically be entered into during the time of employment, but it's really for post-employment activities. That's the kind of thing we're looking for.
Okay.
And not looking for something that, for instance, as a new employee, you're asked to sign on day one.
Okay.
Thank you.
And Mr. Jeffers, you wanted to respond to that one on the papers, is that right?
Yes, Your Honor. Thank you.
All right. Where are we?
27, Your Honor, and 27 can be collapsed together with 28, 29, and 30. These all relate to documents, including payment agreements, contracts with a certain individual who we believe is a high-ranking member of the administration but is not a full-time employee. And so, we've made efforts earlier to identify employees on the employment telephone list, that sort of thing. I don't think this individual will be listed there because he's a contract employee, and I think are entitled to, if he's at the high levels of the administration, I think we're entitled to discover that. And I will also represent to the court that there was a time when an email was sent to the court back on March 24th, and that email was forwarded to a lawyer who forwarded it to the court, and the person who began the email is this individual we're talking about, Mr. Foxworth.
Okay, that's not You're not talking about this court.
I am talking about this court, to Your Honor, specifically as a scheduling email from early March. All counsel were involved.
No, it's not an ex parte thing. I'm not worried about that. I just don't recall seeing this individual's name.
Your Honor, can we not, for the next series, they're going to be asking about certain individuals who have supported the work of the Circuit Attorney's Office. Okay, first of all, I would request that we not put these individuals' names on the record. Is that necessary?
Sure, I'm happy.
And then secondly, Your Honor, these people are individuals. They have rights as individuals. We represent the office as a whole. So with these ones, especially given the sensitive nature of this and the fact that this is a open and public proceeding, can we please submit on the papers on this information, Your Honor?
Yeah, you may, with the understanding that unless you move to seal them, that they're all public records.
Well, at least...
I mean, by your response would be public, publicly accessible.
Yeah, okay, Your Honor, we will consider...
But I'm fine with submitting these things on the papers. The one question I do have for the state is whether, which of your allegations are these relevant to? I mean, I know that this individual is alluded to not by name in the petition, but
yes.
Which of the many counts, which one is this one?
I'm happy to provide that to you, Your Honor. If I tell the court that the number now, to be sensitive to the concern raised by Mr. Jeffers, that's sort of outing it. But I'd be happy to provide that in writing to the court.
Please.
But I will just say, at a broad level, the person that we're talking about in these requests, which will be differentiated from a few requests here in a second, this individual is, from my understanding, somebody who's involved in the high-level discussions about how to dispose of cases in the office, which is one of the issues that we plead in the complaint.
Okay. So that would be your first few counts. 1, 2, 3, the ones about prosecuting and...
Yes, that's my belief, Your Honor.
It's not information about their relationships with the office. It's information about, their other businesses, things that are completely irrelevant to this.
Well, and Mr. Jeffers, just to be clear, and maybe I did a poor job of articulating it, I'm not sure how this individual is paid. So in other words, the payments may be to these LLCs. I don't know. I'm not trying to get the LLCs.
Well, how is the fact, though, in the manner of his payment relevant to your allegations?
Well, Your Honor, I can answer that. It's not favorable to this person, but the short answer is it's our belief that this individual is not a salaried employee because there's a lien.
Your Honor, can we take this up, please, in some more, given that these are individuals and that,
Why don't you go ahead and submit that on the papers, and
Okay.
I'll take it up that way.
Thank you.
Thank you.
And you can put in, if you want to have some time to respond to this too. I know that part of the concern is that we're dragging this out more than any of us wanted to. Yeah. But I'm happy to give you opportunity to reply to their response too.
And Your Honor, I would anticipate we would reply quickly.
Okay.
Would be my quickly, of course, is a famous lawyer word, but I would think a day or 2 or 3 would be sufficient for us to file a reply.
Okay, so if they give me a response in a week, you can do it so that would be next Tuesday, you could do it by Friday?
Yes, Your Honor.
Is that, I know that time is of the essence in this whole thing, but...
About Monday.
Monday? Yeah, well, that's okay with me.
And I'll reserve the right to file it earlier if I can get it done sooner, Judge.
Certainly. How about this then? Since I can see everybody in this courtroom is getting bored with us, we just handle the rest of them that way?
Yes, Your Honor.
And then to the extent that I feel like we need to argue on anything else, I'll call you all back, and I'll call you all back soon on a day that works for me.
Thank you.
And then, and in the meantime, I want you to file responses, but I also want you to try to work out some of this stuff so that we don't have to, so I don't have to do it.
Yeah, okay.
I'm happy to give you a ruling, but I'll tell you that my rulings on these things are going to be more favorable to disclosure than not, just because I feel like that's the way that our system's supposed to work. And so to the extent that you all can iron some things out, I think that would be helpful for everybody.
And Your Honor, I want to make sure I understand the scope of what you're asking us to work out. My understanding is you're looking at what's a time frame for disclosure, what are search terms, where appropriate, where can we agree to limit this time and scope of documents.
Yes.
And you're looking for all of that to be done with respect to all of the all of the numbered requests that they have objected to.
Correct.
Okay.
Yeah, no, I'd like for you to talk about this stuff. So next time that we come in here, that we've all hashed all this stuff out, and the only thing I'm having to do is decide the actual issues as opposed to, you know, going back and forth on all this stuff. So,
Okay.
And maybe that's what I should have done from the beginning of this. But ultimately, I think that there are some things here where you all can work things out if you know, put your heads together. And I understand that there are going to be some things that you just said, we don't, you know, we shouldn't have to turn this over. That's not fair. It's, you know, private. But I'd like for them to be linked up to some type of, you know, appropriate, proper objection on each of these counts, so that we can, and again, you know, to the extent that the objection is based on, well, it's going to cost too much money, or it's going to take too many hours, I'd like for you to give me some idea of what that looks like. So I'd like to get the impression that when I'm reading these responses, that you've actually talked to your client and figured out, hey, this is about what it's going to take.
Okay.
Okay?
Thank you.
And,
Yes.
Your Honor, you're looking for that conference to occur, I would assume, sometime in the next 10 days. Contemporaneously, or this week even.
Yeah,
Contemporaneous with the work that we're supposed to be doing.
Right, yes. I can't tell you when to meet because I don't have your trial calendars in front of me, but what I can tell you is that it'd be a good idea for you to have that done by the end of next week.
Thank you, Your Honor.
ASAP. If you can do it before he has to respond, it's probably all the better.
I would be happy to do that, Judge.
We will do it before he has to respond, and we'll get it done this week so that he can have his response on Tuesday, and we will file our reply.
Wonderful, thank you.
Thank you. Thank you.
Your Honor, if I could make a suggestion, there are a few more issues that relate to motions to quash that were filed by individual employees. I
Yes.
think we could take those up, and I can represent to the court. They'll be much shorter than the motions that the court's heard so far.
I hope so. Agreed. Wonderful, yes, if that's, and there's, you are here for them, okay. Mr. Plunkett, you don't have a motion pending, do you? Okay. Yeah, so, and I'm sorry, counsel. Could you tell me your name again and who you represent?
Yes, Your Honor. Paige Slinsky on behalf of Serena Wilson Griffin.
Okay.
So, Your Honor,
And one second. Is this what you're talking about, Mr. Plunkett?
Is this the motion to quash pertaining to Natalia Berkowitz?
No. Is there a motion to quash pertaining to Natalia filed on behalf? Did you file one? Or is that? Yes, please. You shouldn't be sitting in the back anyway. I think we just ran out of chairs.
Thank you, Judge.
Yeah.
So the Mr. Jeffress, who purports to represent the Office of the Circuit Attorney, filed a motion to quash with the subpoena from the Attorney General to Natalia. So I have questions with respect to the standing of Mr. Jeffress and even his representation, but I certainly want to make sure that if my client is ready, willing, and able to comply. And there have been comments made about business records, and certainly doesn't want to disobey the subpoena or this court's order, but wants to do so. And it's my understanding Mr. Jeffress is trying to stop that.
No, Your Honor, I made this clear earlier. To the extent that an individual employee has office material, in other words, like let's say a case file that has, you know, a confidential informant listed in it and a victim and witness information that, you know, could pose potential safety dangers to them or whatever, it's sensitive information. That employee cannot unilaterally decide to turn that case file, which is the office's property, over to the Attorney General. Of course not. Like, that would make no sense. They could just subpoena all of the individual employees, and then the office would have no right to assert any kind of privilege or to make all the arguments that we've been making here today. So it's so far as it's calling for material that Ms. Ogerkowitz possesses only in her professional capacity, that's not her property. That's the office's property. And it should not be and it's not Mr. Plunkett's decision whether to turn that material over. It's the office's, and of course, ultimately the courts after hearing the office's arguments. So that's the only principle that we're articulating. That's all.
You can see my concern, Your Honor. Under Hancock, Supreme Court case, whether there's a possession, custody, control, also goes to the practical ability to get. Ms. Ogerkowitz could get that. when she collected that information pursuant to a court order being the subpoena. And so this comment about the business records and the ownership, I'm not familiar with any cases that actually state that or would prevent my client from complying with the subpoena just because she's not the quote office, which I also wanted to raise this court as an officer of the court. Mr. Jeffress was pro hoc in with Mr. Hinckley, who I believe to be a witness in this case. So Mr. Hinckley has to be here under Supreme Court Rule 9.03. My concern is the office.
That is true.
I'm sorry?
That is true.
And
Is
so
he here?
my worry is not only that, but the office of the circuit attorney, as this court knows from Joyce matter, I could give you the site, Judge, this capacity portion, there's no legal entity, suable entity of the circuit attorney's office. Now, a subpoena can be to an agency, is my understanding, but the city of St. Louis, through the Board of Aldermen, is the proper entity where someone is in the official capacity, for example, such as Ms. Gardner. Or if it's a personal capacity, it's that individual. But the office itself does not exist. And my question for that, when he says, I'm going to talk to my client, who is his client? You know, the office was comprised of Ms. Ogerkowitz, but there's been no communication with that, and she did not agree to have him represent. So I'm really concerned with respect to the city's ability to hire its own attorney as to whether to move to quash or to be open with the public and open with these proceedings versus someone doing an end around hiring Mr. Jeffress to set policy for the city when that entity doesn't exist.
Well, Your Honor, I'm not setting policy for the city. I'm simply representing the office. Also, I don't even understand. Mr. Plunkett has not filed anything along these lines, and as the attorney for an ex-employee of the office, does not have standing to assert this. He has not asserted it until before this court until right now.
His client has been subpoenaed.
If I may, this is also an issue that affects Ms. Wilson-Griffin too, so perhaps it makes more sense to start with that and then we can see if that resolves some of these issues. Obviously, Ms. Wilson-Griffin also received a subpoena addressed to her in her official capacity, but also her personal capacity. So when we spoke with the Attorney General's office on Friday, kind of what we had outlined as our plan was, we are going to go through and identify all of the documents in Ms. Wilson-Griffin's possession that relate to her employment at the office. We will turn them over to the office so they can review for privilege. It's obviously not our privilege, it's their privilege. And then they will turn over to the Attorney General. Anything that Ms. Wilson-Griffin has in her personal capacity, we will review, and as I will tell Your Honor in a minute, we don't think it's relevant, but that's kind of our obligation. So we have had some discussions about this issue with the AG's office already on Friday.
So that poses problems for me, Judge. The city's attorneys, whoever they may be in this case, would be the ones to review that. Those are the policymakers. They hire their attorneys. They decide what it is that gets done. This is not what Mr. Jeffress, again, who is that client that he's reporting to? If it's Ms. Gardner would then be in the position to act both in her capacity as a defendant in this action, but also as the subpoenaed office in an effort to basically prohibit employees or former employees in my client's case from complying with a subpoena. And so in other words, she's dictating what goes and what doesn't go. I think that's not supported by the case law whatsoever, Judge.
Well, it sounds like what he's saying is that the Attorney General's subpoena should be null and void because they're served on an office that's not capable of having counsel or that's not a real entity, and that the Attorney General needs to go elsewhere.
No, you can subpoena an agency as what I mentioned earlier, Judge, and that's my understanding too.
I know there's not been any briefing on this issue, but does the state have a position on anything that's been brought up? As to whether Mr. Plunkert's client can produce things, I guess there's a couple of different issues here, right?
That's right.
Whether Mr. Plunkert's client can produce things in her possession regardless of whether the Circuit Attorney's Office wants her to, whether the Circuit Attorney's Office has been properly served, whether the Circuit Attorney's Office is the proper entity to be served, or if it should be the City of St. Louis?
Yes, Your Honor.
I don't mean to put you on the spot, Mr. Corrigan.
No, under Rule 5703, a governmental agency can be served. So the Circuit Attorney's Office is a proper party for a corporate designee, deposition, or for a subpoena. In terms of the documents that counsel from Ms. Wilson-Griffin says she's going to turn over, or from Ms. Ogerkowitz, to me, it's a pretty easy solution. The court can either look at those documents in camera
They can bait stamp the documents, provide the documents to the court. That's one option. The other option would be to provide those documents to the Circuit Attorney's Office. Again, you have Ms. Gardner and these lawyers, whether they have a conflict or not, that's a different issue for the court. But in terms of the documents themselves, they can provide us with the bait stamp numbers, and if they think that the documents should be produced by the Circuit Attorney's lawyer, they can communicate that to him, or you could look at the documents and decide whether the documents ought to be produced.
Your Honor, our concern is obviously that we want the Circuit Attorney's Office to review for their privilege. Again, it's not our privilege, so we feel uncomfortable reviewing these documents and making privilege calls. So it would be, as we discussed on Friday with the AG's office, and I thought we were in agreement with, our preference to go through, identify any documents that Ms. Wilson Griffin has that are relevant to her employment, provide them to the office solely for the reason of them reviewing for privilege, and then they will produce to the AG's office. We just don't want to be in a position where we're reviewing documents for that we don't own the privilege on those documents.
So then would your plan be to Bates label those documents so that there was a paper trail of, what's turned over, what it is?
Yeah, I don't think we had thought of Bates stamping, but we would certainly keep a record of what was turned over. And then I know the subpoena had requested a privilege log, so I would expect there would be a privilege log of the documents that the AG's, the CAO's office had designated as privileged.
Okay.
Yep.
And we believe that Ms. O'Gurkowicz should go through the same process, Your Honor. That is the appropriate process, I think, for getting these documents.
Mr.
to
Plunkett,
the
what's your thought on that? If the review is for privilege only?
Well, I just don't like the idea of the defendant being the arbiter of what goes and what doesn't go. Now, of course, if there's a privilege log and if it's produced in camera, certainly I think those are very good protections, Judge, because that means you would be able to be the arbiter, and I think that is how this case should work.
Well, I guess, so one of my concerns is, technically the Circuit Attorney, Gardner, is still the Circuit Attorney of the City of St. Louis, so she is still the head of the office. I understand the concerns that you might have, but to the extent that a subpoena like this would be filed on the Circuit Attorney's office in the normal course of business, which I know is not a fair use of that term right now, who would be the person that would have the final say on that, assuming we're not in a quo warranto action?
Well, I guess when it comes to a subpoena directly to my client, it would be my client.
Right.
Well, if it's subpoena to the office, if you're going to say Kim Gardner has the opportunity to do that on behalf of the office subpoena, I guess those are two different subpoenas and two different final words on that.
Well, your client, was she subpoenaed, and you'll have to remind me, in her official capacity specifically, or was it just, your client subpoenaed, turn over all these documents that you have?
The latter, Your Honor.
Okay.
There's no reference to capacity.
Okay.
But she only has these records, these case files, things like that, because of virtue of her employment, Judge.
And just to be clear, I don't know, I'm sorry, Mr. Plunkett, if your subpoena mirrors ours, but it said in the subpoena that they're seeking both documents from personal devices and official devices.
Okay.
So it did reference personal and official.
So if she has a work cell phone or something?
Or, yeah, if you're
Or
emailing
computer or
personal,
something,
you're
yeah.
texting, things like that. Yeah.
Understood.
Sure, the capacity rule under Missouri law, official capacity is the employer. It's the public entity that employs the individual. Individual capacity is that individual alone. So there's been no reference to that in those subpoenas to answer your question, Your Honor.
Okay. Mr. Corrigan, any thoughts?
The state of Missouri just has concerns, Your Honor, if in terms of the documents being produced, that the decider of that is not the Circuit Attorney's office. That she does run the office. There's a conflict of interest there. I believe that the documents that Ms. Wilson Griffin has, or that Ms. O'Gurkowicz has, if any, those ought to be bait stamped and provided to the court for the court's review or its in-camera inspection and decide whether those documents should be produced or not. That we shouldn't have to rely on the Circuit Attorney's office to make that determination.
Well, I suppose some of what we do depends on what the definition of possession, custody, and control is, right?
Again, I believe Hancock has to do with practical ability to get, and I think an example might be experts retained by a party. So if I retain one, that's someone that's kind of a separate entity, but still I can get that, and I'm required to produce that in discovery, Judge. So I think that would be the same thing as my client when she's working to comply with the subpoena, gathering documents. That's why whether it's on work or individual devices, there's no difference under Missouri civil rules of procedure.
What types of things does your client have that the Circuit Attorney's Office is concerned about? I mean, I understand the way that question just sounded, but what I'm wondering is, I think there's probably a difference between, her having case files and things, and her having, employment-related literature or policies and procedures and that sort of thing that were given to her during the course of her employment that were obviously, not obviously, but they were likely turned over with the idea that she would keep those and comply with those policies.
So, Judge, there are approximately, and at this point, approximately 3,000 pages. This includes emails that are inter-office emails, which pertain to what level of training, whether there was training. Also, emails with respect to concerns regarding being underwater, being overworked, being understaffed, and the work environment that you've heard about earlier today with respect to arguments from counsel. That's just to name a few, Judge.
So to the extent that emails to that like that would be ordered, I would order the Circuit Attorney's Office to produce those, then that would clear the way for your client to do the same, yeah?
Should the Circuit Attorney comply with the court's order, Judge, honestly, and find the documents that my client took the time to find, I agree. However, if you get authorizations to a hospital, sometimes 2 authorizations to have 2 different batches of documents, maybe by no wrongdoing whatsoever. So my client wanted to make sure herself to comply with the court's order, to look for it, which she did, and we'll have them ready. I have them now.
So
Our only concern, Your Honor, is just that we get to be heard on whether those documents are produced. That's all. That we get our say about that before the court. And if the court overrules our objections, fine. But if the court agrees with our objections, then they don't get produced. It's office property.
Mr. Plunkett, what's your, you've not filed a motion or anything in particular so I'm curious as to what is it you want me to do today?
So, Judge, I wasn't positive if the motion to quash my client's subpoena was going to be taken up. What I wanted to let you know was exactly what my client's position was, that my client wants to be clear and comply with everything, does not want to be silenced by anyone else, and I believe with the subpoena and what I've discussed, working through the subpoena, I think that should stand. That should be the source of discovery in this case. So that's my client's point of view.
This may be the appellate judge in me, but would you be able to put something together, some type of brief or something, providing me an authority, an argument for what you believe to be the appropriate solution here, and have that filed within the next 7 days?
Yes, Your Honor.
Thank you.
Would we be permitted to respond to that, Your Honor?
Yeah, by Monday.
Okay.
The following Monday. I want to keep, I'm trying to keep this tight, but not too tight. You understand?
Yes, Your Honor.
Okay.
So, Your Honor, given we did actually file a motion to quash, can we just quickly be heard, because Mr. Goodwin and I have made some progress.
Please. Was there anything further, Mr. Plunkett?
No, thank you, Your Honor.
Thank you.
And I did want to say that we had discussed this with the AG's office, so I'm kind of a little bit confused at the change in perspective now. Mr. Goodwin and I discussed, Mr. Corrigan was also there, that these documents would, because they're related to her employment, be documents that should be sought through the Circuit Attorney's Office. So I did just want to revisit that and ensure either way the AG's office is going to get them. It's just a matter of whether we find them, send them over to the Circuit Attorney's Office, they review for privilege, give them back, and then we hand them to the AG's office, or it goes the other way. We hand them, the Circuit Attorney's Office reviews for privilege, and then they produce them. So either way, the AG is going to get the documents related to her employment in her official capacity. It's just kind of the mechanism.
Are there any, do you have any objections to producing any information, or is the question now just do you have documents that you don't want to turn over, or are we just now trying to figure out how it is we're going to turn these documents over?
We're in kind of a unique situation, Your Honor. So when we spoke with the AG's office on Friday, so just to give Your Honor a very quick background, just so you know for context. So there was a first subpoena that was served on the office improperly for Ms. Wilson Griffin, a second superseding subpoena that we accepted service for on April 5th. We filed our motion to quash on April 10th. And we spoke with Mr. Goodwin and Mr. Corrigan on the 14th. They told us at that time they're seeking to file a third superseding subpoena, essentially so that I didn't need to show up today. But because technically the operative subpoena is still operative and our motion to quash is still pending before the court, I did want to come.
Okay.
So that's where we are insofar as the motion to quash. I will say we are seeking still a protective order as to, and it sounds like, according to Mr. Plunker, we don't potentially might not need a protective order, but what we don't want to happen is we don't, to the extent the subpoena is seeking documents that Ms. Wilson Griffin has in her personal capacity as a citizen, texting with her husband about, the quo, texting with her friends and family, we do not want to produce those. We don't think they're relevant. We think that there's at least 3 cases we can cite on non-party discovery and the relevance, and so we would ask first, that the court issue a protective order as to her personal documents, and then second, that as to the pending subpoena, that the AG's office withdraw that until the 3rd superseding subpoena is issued.
So withdraw the current subpoena until they've issued a 3rd superseding subpoena, and then to
Yes.
prohibit you from turning over any documents that might be specific to conversations she might have had with family, friends, etc.
Exactly.
Things that aren't work related.
Yes, because we'll have further conversations with Mr. Goodwin and Mr. Corrigan once we get the 3rd subpoena and work with them to, produce as much as we can and identify those documents that are relevant to her employment and provide them to the Circuit Attorney's Office. But I don't see a reason why the current subpoena should stand, given that we're here today and we're ready to argue the motion to quash, but it doesn't seem to make sense to address the merits if it's going to be a moot point shortly.
Is the Attorney General's office pushing for documents that would be purely personal?
So, Your Honor, what we're looking for is sort of in two categories. One, I want to make sure that when we send a subpoena for documents, that if the document is only on a personal device, so in other words, if Ms. Wilson Griffin, who's the first assistant, just so that the record is clear, so, extremely high-ranking member, if she's conducting state business on a personal email, for instance, after hours or on the weekend or for whatever reason, that would be a document that would be related to the Circuit Attorney's Office, but not in their possession. I want to make sure that we're capturing that in the universe of documents. So that's sort of piece one.
I can quickly reply to point one because I think it's going to be simple.
Right.
We're of the agreement that we are searching her personal devices, her personal email, everything for work-related documents. Okay. So I don't think that's going to be an issue.
Right. That's the sort of one of the 2 reasons we sent the subpoena. The other reason, Your Honor, is that if she's making statements related to the allegations in the petition, I think that is relevant and discoverable. And the reason is she's so high-ranking in the administration, right? In other words, you've heard a lot today about what did the Circuit Attorney know and when did the Circuit Attorney know it, and what the first assistant knows, who answers directly to the Circuit Attorney, is relevant and I think discoverable as to that issue.
I'd say that's a completely different issue. What she knows and what she thinks and her opinions of what's going on are completely different. We are going to turn over all conversations that she has with Ms. Gardner on official topics, but her conversations, again, with her friends, her family, and Your Honor, I can read you number 3, their 3rd subpoena request. It's incredibly broad. Any and all items, documents, emails, text messages, memoranda, notes, and other records relating to the allegations in the amended quo warranto petition. I mean, it's hundreds of pages, hundreds of paragraphs. I don't think, A, too broad to say what's related to it, but B, Ms. Wilson Griffin's thoughts on the quo petition are completely irrelevant. I can cite to Your Honor 3 cases right now out of Missouri that says that non-party discovery, especially of this invasive type, is completely inappropriate and should only be utilized if the AG has gone to multiple other sources and hasn't been able to find what they're looking for.
Is there a way that we can limit that so that it's not so?
Yes, Your Honor. Some of these, as the court's heard, and this is part of the reason why I made this statement, that I think this would be an easier topic, which turns out to maybe perhaps not have been right.
Yeah, I feel deceived.
So I apologize, Your Honor. Some discovery conversations are easier than others, as the court knows. I anticipate that this is going to be a conversation that's easier than some of the other ones we've had, which is why we reached the agreement to issue a third subpoena, in part after the court rules on the circuit attorney subpoena, because of course that will inform how I want to sit down and draft the third subpoena.
So if I quash this current subpoena and then just let you all deal with the third subpoena and then we can argue about that one, is that?
Well, Your Honor,
would you agree to withdraw this one if you're going to re-subpoena her? Why are we here arguing on a subpoena that you're going to send out a new one on?
And Your Honor, we will send a new subpoena. The only question is, if we send an amended subpoena, how does that work with service? We had a disagreement about service earlier in some of the pleadings. There's maybe an indication that service by mail wasn't good, but of course, Ms. Wilson-Griffin's attorneys who agreed to accept service are only officed out of state, so I can't serve a civil subpoena in another state. I think we've reached an agreement about that.
Council is willing to work together to make sure that the subpoena is properly
Please.
served. I don't see an issue with that.
Please, here's my position on service.
Yeah.
You need to, for a subpoena, it needs to be handed to the person subpoenaed, okay? If you're agreeing to do it,
Yes.
you don't have to comply with that rule.
Great.
You
Yes.
understand?
I don't see that as an issue, Your Honor.
Yes, Your Honor. And, the issue was tracking down personal service of Ms. Wilson-Griffin. I think the Circuit Attorney's Office expressed some concern that our investigator was at the Circuit Attorney's Office in the public areas of the office, to be clear, and they didn't like that.
But this, sorry, I
Yeah.
don't mean to cut you off.
No,
but
no.
This, service is something that I don't have to address right now, correct?
Correct, Your Honor.
Okay.
I think
So-
your question was why we're dealing with this subpoena if there's a third one.
Right, and I
pending.
think the answer to that, Your Honor, is sort of where we began, which is we're going to work together on a third subpoena.
Nonetheless, we would ask Your Honor to withdraw it and to issue a protective order essentially saying that her personal views and personal thoughts and personal documents unrelated to her employment at the city attorney's office are irrelevant and should, be with not disclosed pursuant to the multiple cases that we found on point, Missouri.
You have a stack of documents, it sounds like, that you already believe should be turned over or will be turned over. There's certain things you already agree you should turn over in response to this.
When you say a stack of documents, I'm sorry, Your Honor, do you mean like?
Do you have documents ready to go, or is this a kind of a prospective, like we are looking for these documents and we agree we will turn them over type thing?
Yes, so we actually tried to meet and confer with the AG's office multiple times leading up to our motion to quash, didn't get a response. And so we met with Ms. Wilson-Griffin and have started to identify her relevant documents so we can turn them over.
Okay.
That's not my recollection.
Well, one way or the other, are you going to serve a new subpoena?
If they're going to agree to accept service by email, Judge, yes.
Okay.
But as to the protective order, I just want to make sure that we're very clear here. If Ms. Wilson-Griffin is texting with employees of the Circuit Attorney's Office on her private device, that is discoverable.
Well, as long as it's regarding
Right.
the relevant topics. If she's texting with a friend about their plans later that night or what
Exactly.
her private thoughts are on some issue, that's not something you're looking for, right?
We're in agreement on that point.
Okay.
Great.
So here's what I'm going to do with this one. If you're going to subpoena her again, I don't understand why I shouldn't just quash this subpoena and let you try again.
Yeah, we
You
can
just
do that,
withdraw
Judge.
it? Okay.
Yeah, that's my hope was that we had an agreement here and
Okay.
that,
Well, let's withdraw. So you're going to withdraw that subpoena?
yes.
Okay. And then you're going to work things out.
Yes.
It's becoming the theme of the afternoon. And then on this third subpoena, if you continue to have issues, knowing that I tend to agree with the position that there are purely personal communications that don't have anything to do with this case or, her,
Right, I'm not
Ms.
looking for-
Wilson-Griffin's employment, then those don't need to be turned over.
Exactly. I'm not looking for discussions about recipes or personal thoughts about what to do later. Just looking for documents and communications on professional and personal devices that relate to her employment.
Yeah, there is a distinction there, obviously. Texts about recipes are clearly not relevant. It would be text with friends and family. For instance, when I used to be a prosecutor, I would text and say, I'm so tired, I'm exhausted, something like that. Conversations with her husband about her job, her opinion, I don't think are relevant, so long as the AG's office.
We're not looking for that, Judge, which
Great.
I've said before, I'll say again.
Yeah, so we're talking about
Understand.
communications with office personnel about particular issues.
Exactly.
Yeah.
Yep, great.
Wonderful. Okay,
Thank you,
so
Your
that, somebody's gonna have a fun time trying to write this whole big order up, but, that subpoena will be withdrawn and we'll deal with it down the road here.
Thank you, Your
Right?
Honor.
Thank you. And Mr. Plunkett, you're gonna get me a brief by Tuesday?
Yes, John.
Thanks, sir.
Thank you.
Any other discovery issues to take up before we get to figuring out when we're gonna try this thing? No? All right. Well, let's figure out when we're gonna try this thing. Assuming that, yes. So, before we get started on that, I'm told that at 5:30 they start to shut the front doors of this place. They're going to stay open until we finish? All right. So, never mind. Crisis averted. All right. So, Mr. Corrigan, I think that there are a couple of motions from the Attorney General's office about expediting discovery, expediting trial setting, and that sort of thing. So, and I'd like to just kind of talk to everybody generally about, what do we need to do? When do we need to do it all? And again, I've not ruled on the motion to dismiss. I'm not telling you what I'm going to do one way or the other. But at the very least, I'd like to get this thing in a position where, assuming I don't, we know where we're going, so that we don't have to come back here and do this all over again. Is that fair?
Sure.
If I may approach, I think Mr. Corrigan and I
Well-
are the primary participants.
Well, if I may, Your Honor, it was our motion for expedited trial and then expedited discovery. If I may address the court, and then Mr. Downey can certainly do that as well. And I think Judge Shaw may want to say a few words as well at some point. Your Honor, from the state's perspective, as this court knows, it's been well publicized. Yesterday, Judge Milliken issued an order finding that directly to Ms. Gardner, ordering her to appear in his court for a show cause hearing on April 24th for failing to appear. No assistant circuit attorney failed to appear for trial. And furthermore, a speedy trial was filed in this cause with an end date of April 26th. Defendant is confined, and the court has received no information from the circuit attorney's office regarding the matter. Judge Milliken, I'm holding up his order. He wrote that this conduct thwarts and defeats the authority of the Circuit Court of the City of St. Louis. In another publicized case yesterday, Judge Llewellyn entered an order when no one showed up until late. An assistant attorney showed up later in the day, including Mr. Hinckley. And she has a motion to dismiss was filed by the defense lawyer. That's another murder case. Both of these are murder cases. And that matter has been set for a bond review hearing on Friday. One involves a murder down by the arch. The other one, South St. Louis, involving a mother. It's our understanding, Your Honor, that the circuit attorney's office is essentially down to 2 circuit attorneys handling violent crime cases. And I base that on the fact that, without naming names, I'm happy to do that, but there's been a couple of recent resignations. One circuit attorney is on personal leave. That's been publicized. He's been public about that. The other circuit attorney, assistant circuit attorney, is on medical leave for apparently a knee or some sort of injury. So that really leaves 2 assistant circuit attorneys who are handling hundreds of violent crimes. The state is concerned about the office in terms of its ability to protect the public safety. The state is concerned about victims suffering, defendants suffering, the administration of justice suffering. And so The state requests an expedited hearing. The court knows that. We talked to counsel for Ms. Gardner on Friday and proposed a trial the last 2 weeks of August. Here's a draft of a case management order for the court's consideration. In light of the things that we've talked about today and the discovery disputes that we've had and that I anticipate having in the future, I'm not sure the last 2 weeks of August are realistic. I would love to think that they are. And this case management order has a very aggressive schedule with respect to a trial. The other thing I think makes sense for this court, Your Honor, is to have regular hearings before this court. And I proposed in there, but we're open to whatever works for the court. I would request, and you'll see in Roman numeral number 3, that the court have a standing status conference and hearing date every first and third Tuesday of the month. I picked 1:30, but whatever is convenient for the court. There is going to be ongoing discovery disputes. There's no question about that. You could see the sense of that today. I saw that when we were in the room in the back. There is going to be a lot of discussion, a lot of resistance, in my judgment. They have the right to resist. But in my judgment, there's going to be a lot of resistance, a lot of fighting about discovery. And so I think having a standing hearing makes a lot of sense so that the parties can file their motions. And in fact, if we don't need to take up the court's time, we can advise the court. I proposed within 24 hours, but we could advise the court that the hearing could be canceled. We all know that the court wants us to work together. We all know that. Sometimes that can't be done because people assert what they believe is the right, their rights. I understand that. So I think having the parties before the court on a regular basis to hear motions, I think would make a lot of sense. So that's that was the case management order that I proposed yesterday before, the hearing today. The state would absolutely request the court, because of the need for an expedited hearing, because of what's going on in our community, at least from our perspective, that the court set this for trial no later than September. And I'd love to do the last 2 weeks of August.
Do you think, you said earlier you didn't think that was realistic.
I don't, in light of the way, what we've talked about today, I just want to be honest with the court. I don't think it probably is realistic, unfortunately. But it's in everyone's interest, the communities, the parties, the courts. Everybody is watching us today, not only in this community, but beyond. And it's in everyone's interest to resolve this one way or the other as expeditiously as possible. So that's our position in terms of the setting. I would also say that I don't think Mr. Sullivan is here today. I don't see him anyway. That's correct? So in terms of the discovery, in the expedited trial, I made a list. There are 14 lawyers representing the defense and the defense team from around the country, some of the biggest firms in America. Ms. Gardner has 3 law firms representing her. The Circuit Attorney's Office has 4 lawyers. Ms. Wilson Griffin has 5 lawyers. And Ms. Gardner has at least 5 lawyers representing her. So,
I know it's probably, nobody can give me a promise here on any of this stuff, but once we get these subpoena issues resolved, I suspect that some of these lawyers will be less present than they are now.
Agreed. But all the more reason why we have so many lawyers that we can, hopefully work expeditiously together if that's possible.
I agree. We need to get this thing done. I think the people of the city of St. Louis want it done, and they need some clarity one way or the other on it.
Yeah, agreed.
I'm on board with doing an expedited setting and getting it done quickly, but I'd like to hear from
Sure, of course.
Mr. Downey as to what their position is on when you can get ready for trial.
And Judge, I first of all just want to start off, Mr. Corrigan discussed a number of cases not before this court. All I will say about those is that I am aware of the order that was entered in the Jones case. I believe that the factual underpinnings of that are not accurate. That will be dealt with. What we have said is we understand the desire to move this case quickly, and that's fine. There's a reality here, though. As you've seen, the Attorney General has brought a 128-page pleading with 630 paragraphs. You have the opportunity to narrow that. They've brought a lot of discovery to date that is incredibly broad. They're not very willing to narrow that. They're now saying, give us everything in the world with regard to discovery, and then we want to try the case very quickly. When we had the conversation with the Attorney General's office, I said there's ambitious and then there's unrealistic. As indicated, Mr. Sullivan, Ron Sullivan, is expected to be the lead trial attorney for Ms. Gardner. He was unable to travel to St. Louis today. My understanding there's been lots of flight issues in the last 24 hours. Beyond that, he has indicated he's not available the end of August or the first 3 weeks of September. So we would ask that it be moved beyond that. That having been said, we are fine with trying to do a relatively quick process. If the Attorney General was willing to narrow things, first of all, I think it would show that they really did have a basis for this proceeding, which I don't think they have. If they had something that truly was she accepted funds she wasn't supposed to accept, she refused to prosecute her friends, I don't think we'd be here talking about, Serena's emails with her husband. That having been said, we are. And I would anticipate that there will be lots of discovery. I expect that the Attorney General is going to push things. The schedule, and I presume it's what Mr. Corrigan had sent us was just dates. We didn't see the draft order. You saw me receive the draft order. The deadlines on it were very, very tight. There was, a couple of weeks for experts here and a couple there. The idea was to have a summary judgment motion heard on August 11th and then have the trial start 10 days later. I suspect you are aware that courts usually aren't able to rule on summary judgment motions that quickly. I think realistically we can certainly have this tried in 2023. I don't think it can necessarily be, the early part of September. I'm happy to try to work with opposing counsel. I had not previously heard the idea of having standing calls on every other Tuesday at 1:30. I don't think we have any problem with that, and certainly letting the court know if there's something to be heard or something not to be heard.
I think that's a particularly good idea, that we start having a standing date that we are all getting together. So do you have a proposal for when you and your team can be ready for trial?
I think the most critical thing, Judge, for us is to get the order on the motion to dismiss, see how much is there, and see where things are going. Obviously, if the motion to dismiss is granted in full, there will be no hearing. If you narrow it down and say, counts 1 through 7 are out, obviously it's going to be a lot easier for us to prepare. So I would anticipate, again, part of it is asking the court. I think realistically, if you pick a date, late October, early November, we will be here and we will be ready. And if we want to, if you want to give us a back date, I know I'm used to doing scheduling orders where you get the date of trial and you sort of work backward.
Mm-hmm.
And I think we're happy to do that. And I don't think there will be problems working with the Attorney General on that.
Okay. So late October, early November is what you're looking at?
I think would be realistic.
Okay. And that's assuming that the petition stays exactly as it is?
No, that would be presuming. I anticipate it will be at least partially narrowed. I think also some of the discovery will be narrowed. And the last thing I think I'd be remiss to mention, there's a lot of discussion of things. The reality is that the way the Attorney General has prosecuted this case so far has increased the stress on the people working at the Circuit Attorney's office. When we talk about staffing and things, if they were kept a little more in check, it would make it a lot easier to keep people. People were taxed before. It's a tough job. It's a tough office. And when you throw this in and with what's going on with incredibly expansive discovery, trying to serve everyone in the office with subpoenas, those types of things, that only really aggravates the situation. I know in general we've been very receptive on receiving things. In fact, to receive the actual petition, I sent a lawyer down from my firm. And I do think also it's been said, and I think it should be disputed here, Ms. Gardner has 4 attorneys representing her. She has the 2 attorneys that are at Downey Law Group. She has the only attorney in Mr. Sternberg's firm, and she has the only attorney in Mr. Sullivan's firm. She does not have a large firm. Basically, with the exception of Mr. Sullivan, you see who she has today. There's no big group behind us that's helping out. And we're very glad to have had counsel enter to assist the Circuit Attorney's Office pro bono, and we were very glad to have the assistance we've received. but there's not some army of lawyers here that are preparing to take all this up. You will see me, you will see Ms. Tungate, Mr. Sternberg, and Mr. Sullivan a lot, because that's who works this case.
Okay. Mr. Corrigan, October, early November is too late for y'all? Or Mr. Shaw, if you'd like to address the court, though.
Thank you, Judge. Good afternoon. I'm here on behalf of the judges of the 22nd Circuit, and I'm here for one reason only, Judge. And it's something you've already alluded to, and I'm sure that you understand. The practical effects and uncertainty of the situation we're in now, Judge, have placed the judges in an untenable and unsustainable position. Whatever the cause of it, the Circuit Attorney's Office is now in a state of near total collapse. An expedited resolution of this matter is very important, Judge. It will benefit the parties, the court, victims, citizens, defendants, all concerned. And that's all I wanted to say to you, Judge. Thank you.
Thanks, sir.
Your Honor, I would just say that I think trying this case in September makes sense. I don't know Mr. Sullivan's reason for being unavailable for the first 3 weeks. We all know that we filed a motion for expedited trial at the very beginning of this. He's known that from day one. We all rearrange our schedules, whether it's whatever it is. That's how life is as a trial lawyer. You have to rearrange your schedule from time to time. I don't know if he's teaching. I don't know what his excuse is. For Mr. Downey's nodding. He said he's teaching. But, and good for him. But to me, the business of the people of St. Louis, the state of Missouri, takes precedent over the students at Harvard. And so he needs to either rearrange his schedule to try this in September, in my judgment, or not be involved. I mean, he's known that from day one. We initially asked for a June trial date, which is clearly not realistic. So I think setting it for trial in September would be in the best interest of all of the parties concerned.
Thank you. You have to forgive me. I told everybody not to use their phones, and here I am going to use my phone to look at my calendar. Yes, please. If we look at the last week of March, or not March, wow, that's just what's on this calendar here, I apologize. We look at the last week of September. Are we still expecting 10 days on this trial?
Yes, sir.
At least?
Judge, if things aren't narrowed, it's going to be a lot more than 10 days.
Okay.
I mean, that's an honest evaluation.
Okay.
I believe, Your Honor, that we can get our evidence in, whether the court narrows it or does not narrow the Second Amendment petition within seven working days, maybe 8 the most.
Your evidence in 7 to 10?
7 to 8 working days is what I think. Yes, sir.
Okay. Do you have any estimate at all? No problem if not.
I can just tell you, I mean, earlier there was a 20-minute recess that stretched almost an hour. I'm trying a discipline case right now that involves conduct in underlying cases. There's no way. I mean, there's just no way. So,
Okay.
You know, it's going to have to be longer than that.
What are you thinking?
I think, you know, if we say 3 weeks, I think we'll be lucky.
Okay. The last week of September into October for as long as it takes? Is that a problem for anybody? I understand you'd like it earlier and they'd like it later, but
No, we'll make it work, Your Honor.
So starting on September 25th?
yes. Does that work? That works for everybody? To the extent that anything can work for everybody? Okay. Well, let's plan on that. September 25th.
And
Yes.
The Attorney General's office has submitted a proposed scheduling order that starts with their expert disclosure on June 1. Presuming that date is reasonable, I presume we can then just work the other dates in.
No, why don't we go ahead and revise that in light of the court?
That was going to be the next thing that I asked is if.
Make sure we knew where the starting point was.
Yeah, if we do a September 25th start, trial date,
We'll rework the order, Your Honor, and work backwards from there. I agree.
and you all can agree to that, to work on that? Okay, that's good. And then we still want to do if you want to do the first and third Monday, is the first and third Tuesdays okay if we just schedule it kind of standing for a hearing, and then you all can agree to something and put that in your order if you want, and I can make myself available typically in the afternoons.
Why don't we just agree right now and get it done, Your Honor?
Okay.
The first and third Tuesdays are fine for us. That works for these guys.
Since a whole bunch of us are from out of town, Jefferson City, Kansas City, other parts of the country.
Well, can't they do it by WebEx?
I was going to ask them about that.
This is not my normal courtroom, so I am not, completely aware. I think that may make it more difficult, but I do want to be sensitive to people having to fly in for this, or drive in, or wherever you're all coming from. So I think that we could probably make some kind of arrangement so that certain people can appear by WebEx.
And as I said, Your Honor, there's multiple lawyers representing all these different parties, so it's not, they have to be, one particular one has to be here.
Right. Well, and if we don't need it, then we don't need it, right? And I, of course, will allow, just let me know if we don't need it, or if all of a sudden somebody's got a conflict with a particular date, and we can either decide what we need to do with it. But I think it's a good idea to have kind of a standing what's going on.
So, just so we're all clear, so is it the first and third Tuesday at 1:30? Does that work best for the court?
That should be fine with me. But I don't know. Sorry. That should generally be okay. If there's a problem with it, I'll let you know.
The expectation is start on May 2nd.
May 2nd. Yep.
So, Your Honor, just from the court's scheduling standpoint, and so that we're all aware of it, so our response to their pleading is due May 1,
Yes.
which is a Monday. Happy to proceed on Tuesday, if that works for you.
That's fine with me.
Okay.
Yeah, I read everything you all file as soon as it comes through. Just so I've read all the responses and everything. So, okay, well, let's do that. So, I would like for you all to do your best to write up an order on what's going on today. I have some memo pads here. Do you think that's something that we can work out? And then you'll bring it back to me and I'll sign off on it? Or do you want me to, would it be easier for everybody if I just put together an order and have it submitted by tomorrow?
That'd be better for you.
Yeah, that's fine. I'll do that then.
But how about if we get you the case management order proposed case management order by, when would you like that by?
That is something that, can you get that by next week, the end of next week?
Sure.
Is that okay? Okay. Is there anything further? No, Your Honor. All right, we'll be in recess. Thank you, everybody. I apologize to any of the reporters whose deadlines we may have missed.
This has been a 5 on Your Side special report. We now join regularly scheduled programming in progress.